Division Bench Item 1, PIL Sumotu 1/2020.
Lord, in this matter, I am also there for respondent number 8. Mr. Kohli is already on legs. He's been reaching another 5 minutes, my lord. Actually, I didn't like to, he's gained the momentum. I did not like to break it. But if necessary, I'll supplement at the later stage. By the way, I was just thinking aloud, my lord. If state seeks to derive their authority from Article 371, then the next question which will fall for consideration is 371 an enabling provision to make any legislation?
That's basically the point
Yes.
Mr. Kohli was
Yes.
submitting.
That can't be the enabling. Rather, my lord, 371 is a restriction on the power of the parliament to make law in certain regard. End of the day, if the state seeks to
what we
derive the
understood-
authority,
What we understood is that the parliament would have the power,
yes,
but it would be the state to accept it or not. That
Yes.
371 is the enabling power of the state to accept it or not to accept it.
correct.
That's what we understood till.
Yes, correct. So that is how, my lord, things have progressed. Only thing is, my lord, end of the day, entry 49 of list 2, it has its own limitation. And the expression, my lord, land and its resources in 371, to what extent that meaning can be stretched?
Actually, that is the question last, which was put by my esteemed brother. And that is what Mr. Kohli was responding to.
Yes. It's a very interesting topic, my lord.
Yes, at least for us, yes.
No, even for every one of us, my lord. In fact,
Not always we have this kind of argument.
exactly.
Because if rather, I'm sorry to say, if the young members of the bar would have been here, they would have been more benefited than anything else.
In fact, my lord, Lordship would recollect in the erstwhile, be it Assam General Sales Tax or VAT regime, there are good debates used to take place. After this GST has come in, my lord, it has become like a Raijo. So, end of the day, my lord, now entry 54 is almost not there. So there is no scope to debate at the High Court level, my lord. Earlier, my lord, whenever state is to come up with some law imposing some tax, then the question of legitimacy of the state action used to be challenged. Then we used to have this debate. In fact, my lord, between 2007 and 2012, I did a lot of cases on tax. That is how I learned a little bit, my lord. And that is paying the dividends as of date. Even our High
And-
Court, my lord, did those entry tax
And
matters.
I was benefited out of that because at those days, what I said, young members of the bar would be
Correct.
sitting behind. And I was sitting behind and you were arguing against P. Chidambaram.
My lord, I'm just
Yes.
taking your lordship's 1 minute time. My lord, one argument which I advanced in entry tax matters was, when the tax is non-discriminatory, where is the requirement to comply with 304 Part B?
That was answered
argument
recently.
Yes, that argument of mine was rejected by this honorable court, but it has been upheld by the 9 judges bench mine.
Yes.
Because in J.K. Krishna, the Honorable Supreme Court says once the tax is non-discriminatory, then there is no requirement of comply with Part B. In fact, that is what has been held. And everybody relied upon, my lord, Atiyabari. The Atiyabari only scope was whether a taxation law would come within the ambit of Part 13 of the Constitution, nothing beyond. It was said, yes, it will violate 301 if it impedes the free movement. Only to that extent, nothing beyond that. So eventually, my lord, all these things has been clarified in this 9 judges bench.
Yes.
In J.K. Jindal's case.
Huh.
I think Honorable Chief Justice Kapadia led bench. Please come. My learned friend has come.
I'm so
I'm
sorry.
deeply obliged.
I'm so sorry. Manoj, I didn't realize Guwahati traffic is like Delhi traffic only now.
No. Maybe you are wrong. It's Bangalore traffic.
I just didn't realize. Manoj, I was told it'll take around 30-35 minutes. So we took a margin also, but took almost an hour getting here today. I'm so sorry, Manoj. I'm
But Mr. Bhargopal, when I'm saying Bangalore traffic, I have no offense to you.
The right note one has to be really careful.
Hmm? That is something beyond law, one must know.
Yes, yes. With my Lord's permission, on the previous occasion, we had dealt with those two issues on maintainability, the
My
131.
my brother's last question was to you that about that interpretation of the word land and resources.
And land and resources, one other question which had fallen from my Lord was relating to the prayers in the suo moto Lord's order. The Lord's challenge was to the rules and regulations and not to the main act. That was the other question which had fallen from my so, before I straight away to answer that question, if will just please see 3 or 4 orders, which have been passed by this honorable court, just to set out the context in which those prayers presently are, and what could possibly be a way forward as far as the prayers are concerned. If will please have the order of 8th of October 2015. That was the first order which was passed, when notice was issued and the stay was granted on 8th of October 2015. And if will have the third page of the order, towards the bottom of the page where it says submissions made by the learned counsel for the parties have received the due consideration of the court. Issues raised in this PIL may require further deliberations of the court. In view of the above, let this PIL be admitted for regular hearing. My lords are with me? No, that'll be the third page of the order, notes towards the bottom. Lord Justice Chaudhary is with you. मैं दिखा रहा हूँ जी 8th of October 2015. The first order when it was notice was issued and the stay was granted. In fact, if Manoj will have the first order, Manoj, it records a part of the submission which was made by the petitioners at that time and which specifically dealt with the Naga Act, Manoj. So if Manoj will have on the first page itself, the fourth paragraph, which Manoj starts with learned senior counsel for the petitioner submits that state of Nagaland had enacted the Nagaland Ownership and Transfer of Land and its Resources Act 1990, which governs prospecting or mining operations in the state of Nagaland under license or lease granted by the state. This is a substantive enactment governing exploration of crude oil and allied activities in the state of Nagaland. He submits that an amendment was brought into the aforesaid act by the Legislative Assembly of Nagaland in the year 1995, but the Amendment Act is yet to receive the assent of the President. Notwithstanding the availability of the aforesaid Act of 1990, which is governing the field, state legislature has enacted to impugn Nagaland Petroleum and Natural Gas Regulations 2012 and Nagaland Petroleum and Natural Gas Rules 2012, which provide for exploration of crude oil and allied activities. Referring to the various constitutional provisions relating to conduct of legislative business, learned senior counsel for the petitioner submits that the impugned regulations and rules do not meet the constitutional requirements. Further contention is that when the 1990 Act is occupying the field governing the particular subject, it is not open to the Nagaland Legislative Assembly to have enacted the impugned regulations and rules of 2012. Further contention of the learned senior counsel for the petitioner is that the impugned regulations and rules under which the permit has been issued to Respondent 7 do not provide for requisition and acquisition of land of the affected landholders. So, Manoj, this is now just concerning what exactly was bothering the petitioner when the petitioner came to court. Manoj. Do not provide for requisition and acquisition of land of the affected landholders for the purpose of drilling and other activities relating to oil exploration, thereby seriously jeopardizing their valuable rights over their land and property in as much as the provisions that they have enacted only provides for sharing of revenue on discovery of crude oil in a particular ratio. In the event crude oil is not discovered, state has not made any provision for providing compensation to the landowners and to other affected persons for use of the land. He has also referred to the provisions of 371A of the Constitution in support of his contention that considering the special status of state of Nagaland within the Union of India, adequate safeguards are required to be adopted by the state while allowing extraction of mineral resources of the state so as to protect the interest of the indigenous tribals of the state. Referring to the antecedents of respondent number 7, Senior counsel for the petitioner submits that respondent 7 has been incorporated in 2012 and had already suffered adverse orders. And notes then, of course, then notes after the submissions, please see page 3, the last part notes which I was referring to. Issues raised in this PIL may require further deliberations of the court. My lords are with me? In view of the above, let this PIL be admitted for regular hearing. Respondents 1 to 6 are represented by Mr. T.V. Jamir, learned additional advocate Nagaland, whereas respondent 7 is so-and-so. On due consideration of the view, we are of the view that Union of India represented by the Secretary MOPNG is also a necessary party to the present proceeding and accordingly Union of India be added as respondent 8. Office to make necessary correction. Then notes may have the next para. Article 246 of the Constitution deals with subject matters of laws to be made by Parliament and by the legislatures of the state. In terms of Article 246, 7th schedule of the Constitution envisages three lists enumerating different subjects covered by the three lists: union list, state list, and concurrent list. Subjects enumerated under list 1 are within the exclusive domain and legislative competence of the Union Parliament. Entry 53 of list 1 deals with regulation and development of oil fields and mineral resources, petroleum and petroleum products, other liquids and substances declared by Parliament by law to be dangerously inflammable. Thus, prima facie, we are of the view that exploration of oil and natural gas is a subject which is covered by entry 53 of Union List, which means that it is the Parliament which has the legislative competence to enact laws on this subject. So, Mlods, 53 had attracted the attention of the court even at the start, right at the beginning. Article 371A of the Constitution deals with special provisions with respect to the state of Nagaland. Clause 1A of 371A provides that no act of parliament in respect of religious or social practices of the Naga. 2. Naga customary law and procedure. 3. Administration of civil and criminal justice involving decisions according to the Naga customary law. And 4. Ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. A careful reading of the aforesaid provision would show that no central legislation in respect of the aforesaid subject shall apply to the state of Nagaland unless the same is adopted and made applicable to the state of Nagaland by the Legislative Assembly of Nagaland. This constitutional provision, which has been heavily relied upon by Mr. Taka Masa, learned senior counsel for the petitioners, in our opinion, is meant to ensure protection of various aspects of the Naga way of life and social practices, as well as ownership and transfer of land and resources. It does not, in our tentative view, confer further competence on the Legislative Assembly of Nagaland to legislate on a subject which is within the exclusive domain of the Indian Parliament. This is an aspect which may require further deliberation by the court. Since the very source of power for issuance of impugned permit is in favor of R7 is highly questionable, both legally and constitutionally, we are of the view that it would be in the interest of justice if the effect known and then they grant a stay. He goes on to say this is more so because we have noted that the impugned regulations and rules are not only legally questionable, but those do not provide for any safeguard and provision for the compensation to the landowners in the process of oil exploration until and unless oil is discovered. Moreover, R7 has failed to show any activity and therefore it is stayed. Notes 2 or 3 issues which come out of here. So entry 53 was already within the zone of consideration as far as the court was concerned. Once 53 was in the zone of consideration, the Naga Act itself, not just the rules, regulations under which the rules and regulations really have been notified under in exercise of delegated legislation under the Act. Now, once the Act itself is in question, then the rules and regulations will automatically be subject to the same challenge. So, from this order, what I wanted to point out was that the Naga Act, regulations, and rules, all three were in the zone of consideration as far as competence was concerned. Now, we'll have after that, the next order relevant is the 4th of February 2019 order, when the petitioners sought to withdraw the petition, but keeping in view the importance of the questions involved, this honorable court made it into a suo motu public interest litigation. 4th of February 2019, Manoj. This is a slightly longish order, which we will need to go through.
This we have gone into many times. The last operative part is the relevant one which you want to refer.
Manoj, I only wish to rely on it for one thing, Manoj. So, Manoj, when the request was made, the background in which the request was made, namely, Manoj, the MOU had been signed, and therefore, Manoj, they said that they don't have any cause of action. Their issues are all addressed. But, Manoj, the issue of competence remained. Manoj, competence, as my lords, Manoj, have dealt with several times, can't be granted or conferred by consent. It has to find its source somewhere, Manoj, in the constitution. It can't be otherwise, Manoj. So, not just me and the learned AG sitting and agreeing on something will not grant competence. It has to find its source somewhere, Manoj. Now, after that, considering if Manoj will have, Manoj, I'll straight away go to the operative part, which is at page 7 of the order. May have, Manoj, page 6, the last paragraph. Manoj, this is after quoting the 8th of October 2015 order. Manoj, please see the last paragraph at page 6. Though the applicants have prayed for withdrawal. My loans are with me. Manoj,
Yes.
the 6th page of the order, and just after quoting Manoj, the 8th of October order, it goes on to say, though the applicants have prayed for withdrawal of the said PIL number so and so, however, for the reasons above and considering the views expressed, the observations made, and the findings of the court in its order of 8th of October 2015, passed in the said PIL, and the observations and finding of the court made in the said order that the Naga regulations and Naga PNG rules framed under the 2012 regulations necessitate further deliberations of the court. We are of the opinion that subject involved in the said PIL contains legal and constitutional issues which are also of public importance. It is to be noted herein that after considering all the issues, including legality and constitutional validity of the said 2012 regulations and 2012 rules and noted above, the court by its order dated 8/5 admitted the said PIL. We therefore direct the registry to register the said PIL as a suo motu PIL, and then Manoj, the 6 issues are noted. Manoj, these are important if Manoj will permit me for a moment. Manoj, pertaining to the Naga PNG regulations, Naga PNG rules, invitation for expression of interest, which is a consequence, and will have 4 after that, which says the notification so and so issued by the chairman Naga PNG board, Kohima earmarking oil and gas zones in Nagaland as per so and so. The permit which has been issued notes to R7, all actions done in pursuance to the Naga petroleum regulations and rules. Now, in these 6 points of consideration, I'm unable to ascribe any reason to it. The act itself is not mentioned. That is not mentioned, Manoj. Possibly, Manoj, because the act was never challenged in the original petition. And therefore, Manoj, the court also did not, but in my humble submission, if Manoj will permit, after that, Manoj, we'll see the party respondents are all laid out. And Manoj, I'll just go through a couple of other orders which have been done. And I'll come back to this order, Manoj, because this is really the zone of consideration as far as the PIL is concerned, and which is suo motu, which is not set out by this honorable court. There have been some amendments to this zone of consideration. In the orders which came to be passed, for instance, on 9th of February, 2019. If Manoj will have para 4 of that order, 9th of February 2019. No, 9. There's an order of 9th also. 8th ka bhi hai, 9th ka bhi hai. 9th of February. 9th of December, I'm so sorry, Mlod, 9th of December 2019. I'm so sorry, Mlod. There is an order of 8th of February and then Mlod 9th of December. I'm so sorry. Yes, if Mlod will have para 4, matters relating to constitutional and legal validity of the Naga regulations, PNG regulations and PNG rules, whereby the chairman, PNG board, Government of Nagaland in exercise of its powers under 371A14 pertaining to ownership and transfer of land and its resources under the said 2012 regulations and rules in terms of NIT so and so has granted a permit. Manoj. As per the provisions of Article 246 of the Constitution of India, Parliament has exclusive power to make laws with respect to any of the matters enumerated in List 1, that is the Union List of and entry 53 of the Union List relating to regulation or development of oil fields and mineral resources. And therefore, it being a union subject, the union has exclusive legislative competence to enact. 371A of the Constitution of India relates to special provision with respect to the state of Nagaland, which is under Part 21 of the Constitution and pertains to temporary, transient, and special provisions. It is also settled that in case of inevitable conflict arising between the union and the state powers, the union power and as enumerated in list 1 shall prevail over the state power. Further, in the case of associated natural gas versus Union of India reported in so and so, regarding the Gujarat Gas Act, the Honorable Apex Court held that natural gas being specific entry 53 for any petroleum and petroleum products of the union list, state legislature has no legislative competence to pass any legislation in respect of natural gas, and to that extent, the provisions contained in the Gujarat Act lacks legislative competence. Same thing will apply here. If 53 is interpreted by the Supreme Court, that's the way it is interpreted. The matter is pending for disposal, and so the point of reading this order is that as far as entry 53 is concerned, the court was also aware that now there is a judgment of the Supreme Court which says that gas is the exclusive competence of the union. Now, which leads me back to the question, the suo motu order of 4th of February, which concerns those 6 items, while it should actually have concerned the Act also. The Naga Land and Resources Act should also have been the part of the consideration whether that act can also transgress entry 53. In fact, when this order was passed, it was possibly incumbent upon the respondents to bring to my lord's notice that this also should be amended, and that order of 4th of February 2019, which lays out the 6 points of consideration, should actually be 7 points. The Naga Act also possibly in the zone of consideration. Now, after this, if will have the order of 15th of March 2021. In 15th of March 2021, that further a subset of a point came on Article 131. Whether this court would have jurisdiction or would it be solely the Supreme Court of India? That point we argued last time, and we of course once one decide, we will all read what is decided. Now, if we'll have this order of 15th of March 21 for a moment. Yes. No, it says the learned, I read the second paragraph. No, the learned senior counsel for the respondent number 8 has submitted that the facts based on which the writ petition was filed prima facie discloses existence of a dispute between the central government and the state government regarding the rights of exploration and extraction of petroleum and natural gas in the state of Nagaland. Accordingly, he submits that the provisions of 131A of the Constitution would apply and the issue raised before this court. All sides have no objection if the said issue is heard as a preliminary issue on maintainability of the writ petition. Accordingly, all sides are put to notice. That part we've already argued. I'm only pointing this out because this again another issue came up aside of the 6, but only a subset on maintainability, and which we've already argued. Now, Mlod's may have 14th of February 2024. No, this is the final order. I'm so sorry, Mlod, for taking my notes through the entire history. But I'll just make my point in one moment, Mlod, once we do this.
What did you get, 14th?
Of February 2024. Oh, I'm so sorry, 2023. It has been rather long, this matter. I keep getting confused between the years. 14th of February 2023, will have the third page of the order, which starts with in course of deliberation. Taking note of the order of 4th of August 2022, two queries of the court are as follows: whether in the light of Article 371A, A1, 1A4 of the Constitution, in the absence of any resolution of the Legislative Assembly of the Government of Nagaland, would have the legislative competence to frame the Naga PNG regulations and Naga PNG rules. The absence of a resolution would give them competence or not was the question. Again, this would be a subset of the 6. Whether the regulations and the rules are within their competence, another way of looking at it. And the second was, which came up, was whether the PIL, whether in a PIL an act can be questioned or not, which also we've already argued. Now, in my humble submission, the act itself, the Naga Act, which is part of the Nagaland Ownership and Transfer of Land and its Resources Act 1990. Some of the provisions of that act, as fell from my load, which define mineral oil, deal with how oil is to be or gas is to be dealt with. Those may require consideration on whether they fall foul of entry 53 and whether that act, at least in parts, was within the competence of the state of Nagaland or not, or the Legislative Assembly of Nagaland.
Because the act is not under challenge. That would only be an academic exercise.
No, in fact, my submission is actually based on, because in the suo motu 6 points which this court laid out, there should actually be 7 points. That's my prayer. There should be 7 points. The act also needs to be considered.
Causes omissus.
No, yeah, I can only pray. That only my notes can, of course, we can modify the order notes. But my prayer is, so there are 2 ways in which this can be done. In the interest of efficiency, my prayer would be if on an oral submission, only that point maybe.
That would not be possible because of the fact that this is a 2020 PIL. Without putting a parties to notice, that is something which we can't actually take up, even in a what you call, as you may say it, in a collateral proceedings.
The other way, the only other way in law which I am aware of is where we move an application, and then we formally pray that this order should be amended, and the 7th zone of consideration, whether the act is within the competence of the Naga Assembly or not, would also need to be considered. Now, to that extent, I on my part thought that maybe an oral prayer, but I fully follow what falls from my that given the vintage of the matter and that without putting everybody to notice, it may not really be proper. It's possible, maybe, but not proper to make that. But I will be addressing arguments on this act also. So that part will cause a problem subsequently. If there is no formal prayer and the suo motu order doesn't reflect it as a point of consideration, that may become a little bit of a contested point.
Because you see, there's another way to look into that. The prospecting license and whatever is sought to be done is under the rules.
The rules find their the
source is act.
The act.
But per se, there's no challenge to that act itself. The competence of the that was never challenged, and therefore the prospecting license and all which were the subject matter brought by way of a PIL by Lotha Ho, was limited to the extent of protecting their
Yes.
rights.
One little issue that will come over there, Manoj. So, Manoj, the challenge to the regulations and the rules is not based on the premise, Manoj, that they go beyond the act.
No,
It's not on that. The premise is that they are outside of the competence of the legislative assembly. The Naga government, which would have
basically they wanted protection of their rights.
yes,
That
yes,
is the basic issue.
that is the basic issue. Now, whether Manoj, the regulations are within the competence of the Naga assembly or the Naga government, Manoj, because they would have been notified, that's one part of it, Manoj. But the premise is not that they go beyond the Parent Act. So, Manoj, in that case, I could have maintained the petition independent of a challenge to the act. Manoj, my premise is, or Manoj, what is being considered by the court, Manoj, is whether they had competence at all for the regulations and the rules. Now, which, Manoj, it means that if they didn't have competence for the regulations and the rules, to that extent, Manoj, the competence of the act is also absent. And therefore, the act itself would be a point of consideration, whether it remains or not. Now, as I said, this is more than oversight and possibly cost of some misstatements from our side, where this should have been pointed out earlier. Unfortunately, we are where we are. And in my humble submission, this is something which will come up for consideration for sure. Because I will be addressing on this part, that this act itself is a little off. It doesn't fall within the competence of the assembly. Now, to that extent, I would defer to my lord's higher wisdom on whether an oral prayer, if would want us to put a written application and notice to the other side lords. I'm so sorry.
Because in a lighter note,
No,
we were thinking that in a free country,
no,
putting fetters is not what we should do.
yes, no.
We leave it to your wisdom because
Yeah.
we can't take over the advisory role and say,
Absolutely, it can't.
So
I'll have one little prayer over there.
because then what you do in future is your call.
No.
We won't say anything.
No.
But for the time being, whatever issues are there, on that we can consider it and move ahead.
No. So that
Because we
extent,
wanted to, in fact, since it's a special bench, constitution of and reconstitution of a bench is very,
I fully follow that, Manoj, and I'm
And,
so sorry, Manoj.
and today we have ensured also that we only have one matter in the board.
Yes.
So in the cost list, you'll find there's only one matter.
I'm so grateful.
There's no other matters listed. So therefore, we have some sort of urgency because 2020 matter we can't be prolonging.
Yes.
That's-
2015
that's-
actually.
No.
The
PIL Sumoto is
registered in 2020.
PIL Sumoto 2000.
No, that is over. One part that 2015 is
15
over.
is over.
So now it is a Sumoto, and you see in the entire country they are being now they are mapping all matters.
I know, Manoj. I know exactly, Manoj. Yes.
So we also have those
I
periodical meetings and all.
I
We are under immense pressure.
Manoj, our difficulty was, Manoj, that after the last hearing on the 8th, Manoj, we immediately took up this issue. But unfortunately, Manoj, between the 8th and now, Manoj, there's been a bunch of holidays. So, Manoj, because of which we haven't been able to, otherwise, Manoj, we ourselves thought that maybe best would be to put in an application.
But
But
it's okay.
I-
Whatever matter is there as on board, as on today,
Yes.
we move ahead.
Manoj, I'll continue with my arguments, no difficulty on that. I'll have only one prayer, Manoj. Manoj, I have made an oral prayer. Manoj may decide on the oral prayer so that Manoj, we also know the clear path ahead is that either we move an application or Manoj, that's where it is.
We'll see to that when we pass orders.
Yes, Manoj, Manoj, if Manoj could mention it in today's order, Manoj, I'll be very grateful for that, for the oral prayer, Manoj.
We'll see, when we pass orders, then we'll consider.
Yes, no, of course, Manoj. My Lords will consider. So, Manoj,
Yes.
yes. No, Manoj, aside of these orders and Manoj, this little issue about Manoj, how that prayer is to be made and how the Naga Act, Manoj, whether it will be in the zone of consideration or not. Manoj, what my Lords will have to consider is, Manoj, finally, Manoj, what has been stated in that order of 14th of February 23, whether Manoj, in the light of 371A, 1A, 4, absent any resolution, Manoj, would competence automatically confer upon the Naga Assembly, or Manoj, something more is required, or absent the resolution, Manoj, absent the regulation, so Manoj, there are three possibilities which present themselves. Manoj, an act of parliament is there. Now, Manoj, the first Manoj, process is there will be, Manoj, and I'm sure my learned friend will, Manoj, elucidate on that. Manoj, there would be a process within the Naga Assembly, and I'm given to understand, Manoj, there is, where, Manoj, an act of parliament is identified as falling foul of the four exceptions. That will be the first process. Now, Manoj, if the act falls foul of the four exceptions, then absent a resolution, the act will not apply. That's one part, Manoj. The second part is, Manoj, there is a affirmative resolution and therefore the act applies. Now, Manoj, whether while passing a resolution, is it possible for the assembly to, Manoj, make some amendments to that act and then go for presidential assent and then, Manoj, make it applicable would depend on, Manoj, whether the subject matter is in list 2 or list 3. But list 1, there would be no question of 254 applying and, Manoj, the Naga Assembly, Manoj, amending any act of list 1 and seeking, Manoj, the presidential assent on that. That's the second scenario, Manoj. The third scenario, very interestingly, Manoj, which has presented itself in this case is where it's not absent a resolution. There is a positive resolution which says that the act will not apply. And then, Manoj, which goes on to confer upon the assembly competence to legislate. So, Manoj, what my Lords will have to, in the third scenario, Manoj, which presents itself, what my Lords will have to consider is whether is it possible for the Naga Assembly, or Manoj, is the resolution that is contemplated in 371A, Manoj, does it contemplate within its fold a resolution granting competence to the Naga Assembly? Would that be, Manoj, something which is in 371A? Or is that something even beyond 371? And, Manoj, of course, my learned friend's case is premised on the word notwithstanding. That notwithstanding anything contained in this constitution, we are able to. Manoj, my humble submission, and Manoj, as fell from my Lords last time, Manoj, the direct answer in my submission, Manoj, to that question is no. The Naga Assembly cannot confer competence to itself. It is only the Constitution of India which can confer competence. Absent that competence, there is no possibility of the Naga Assembly arrogating to itself such competence and legislating.
But please come to page 142.
Manoj, of the petition, Manoj?
Yes. This is the resolution you are referring to?
Yes, Manoj. I just one moment, Manoj.
Annexure 16.
Yes, Manoj. Page 142.
Yes. It does not say that the Central Act.
It doesn't say. Manoj, we'll just go through this resolution for a moment. Manoj, may just be with
It
me.
doesn't identify a particular act which says that it is contrary to Article 371A.
Better still, Manoj, so there is the resolution is absent. Manoj, may please be with me. May have know the heading itself. It says resolution, the Nagaland ownership and transfer of land and its resources. No, it doesn't say the word act, it should have. The Nagaland Ownership and Transfer of Land and its Resources Act in respect of minerals, including petroleum and natural gas, Resolution 2010 by Legislative Assembly of Nagaland under Article 371A of the Constitution of India, whereas the Constitution of India makes special provision with respect to the state of Nagaland in respect to the ownership and transfer of land and its resources in relation to the applicability of the Acts of Parliament. And whereas it has become necessary for the state of Nagaland to regulate by law the ownership and transfer of land and its resources. It is therefore, note, I'll come back to this second paragraph, note, on the presumption that they have the ability to regulate. It is therefore resolved by the Legislative Assembly of the state of Nagaland in the 61st year of the Republic of India as follows, that no act of parliament in respect of ownership of transfer of land and its resources, which includes minerals, petroleum and natural gas, shall apply to the state of Nagaland. Now, lords, this is the part where what fell from my lords, the negative resolution that it won't apply. And then it goes on to say further, lords, as provided in the Constitution as 371A, notes that article is reproduced. And then it says it is also resolved that in respect of ownership and transfer of land and its resources, which includes minerals, petroleum and natural gas, the state of Nagaland shall make appropriate modalities to apply and enforce in the state of Nagaland. This is where they assume competence, that the ownership of land and its resources lies with the Naga people, and therefore the state of Nagaland, representing the people, shall have the jurisdiction in relation to in regulation and development over minerals, including petroleum and natural gas, etc., in terms of usage, and shall have the control on the matter of exploration and development in the state, which will include acquisition of mineral-bearing areas, fixation of land compensation rates, landowners' share in the benefits or royalty arising out of the extraction of the minerals. In view of the requirement of getting the mandate of the people through a resolution in the Nagaland Legislative Assembly, it is resolved that fresh modalities will be framed by the state of Nagaland on petroleum and natural gas and development, adopted by the Naga Assembly on 26th of July 2010. There are, as I said, two parts to the resolution. One, where they say that nothing relating to ownership and transfer of land and resources, no act of parliament shall apply. This is without, as fell from my lords, no particular act is identified. It doesn't say the act offends ownership and transfer rights or relates to land and resources. Doesn't do that. And then below the second part of the resolution, which assumes jurisdiction, or in a manner confers upon itself, the assembly confers upon itself the jurisdiction to deal with such matters. Now, in my very humble submission, my endeavor would be to persuade my lords that A, the Naga Assembly can confer upon itself no such competence. That will be absolutely an act dehorse the Constitution. It will not be notwithstanding what is contained in the Constitution. It will be notwithstanding the Constitution. And which cannot be sustained. Not in a court of law, in my very humble submission. The second part, Manoj, would be whether, Manoj, the Act of Parliament would be applicable without due consideration of what does it actually offend. Land and its resources, does it offend ownership and transfer, or is it only merely regulating the development without touching ownership and transfer? None of that has been considered, which of course, Manoj, now this honorable court will. Again, on the lighter note, Manoj, all the difficult things seem to arrive at the doors of the court, Manoj.
Who is the license or license or permit? Part of this PI.
Manoj, which was granted. Yes, that will be Manoj part.
Which?
Manoj, that will be if Manoj will have. Manoj will have page 177 is the permit, Manoj, annexure 24 is the permit which has been granted. Manoj, are with me?
Yes.
Manoj, this is dated 28th of February 2014. It says permit. This permit is issued to the Manoj, the respondent 7 in accordance with the state legal framework on PNG with the following particulars, which is the location, Manoj, and the permit fee is mentioned. This permit will come into force subject to signing of agreements enumerated in paragraph 8 of the agreement MOU dated 28th February 2014, signed between the government of Nagaland and the company aforesaid under Rule 15(1) of the Naga PNG rules. The permit accordingly takes effect from the signing of the last of the agreements referred to in para 9 of the agreement and submission of mandatory works. Permit is valid for 10 years.
What is rule 15?
Rule 15 of the PNG rules, Manoj, just one
Nagaland Petroleum.
of the rules, Manoj, will be.
Nagaland Petroleum.
I'm sorry, Manoj.
Is Nagaland Petroleum.
Yes, Nagaland Petroleum. Manoj will find that at annexure 18, page 157.
15(2).
15. Agreement to be signed, Manoj, it's at page 163. 15(1), a decision on the MG.
Agreement to be signed.
I'm sorry, Manoj.
Agreement to be signed.
Yes, agreements to be signed.
What is MG? What does it mean? MG?
No, I'll just put in one more.
Ministerial group.
Yeah, ministerial group. I'm so sorry, Manoj. Yes, ministerial group.
Ministerial
Because
group.
they had no 3 layers by which it goes. This is the ministerial group. Manoj, after the Manoj will have page 158.
This permit is equivalent to a prospecting license.
Manoj, this is a permit, and then there are Manoj, would that be the position? That it will be a prospecting license because Manoj, they.
Permit or prospecting license or what exactly?
Yes, whether they are different or the same, we'll have to, I'll just look into that. If we'll have page 158, rule 3,
158.
the organizational structure. My lords are with me? It says organizational structure, look at page 158.
What kind of license, permit, what is this?
Yes, I'll just do that. If we'll have the organizational structure for a moment. It says in 3(1), the superintendent's direction, regulation, control, and other connected powers in relation to all operations under the regulations and these rules shall be vested in a 3-level organizational structure as under. With the first level being having absolute command and control over the next 2, the second level having the command and control over the next 1. A group of ministers, that's the GOM, headed by the Chief Minister of Nagaland and comprising 2 or more ministers, including the minister in charge, which shall be known as the Ministerial Group. Petroleum and Natural Gas, shortly MG, shall be the first level. So, this is the pinnacle, the top of the pyramid. A core group of officers of not more than 3 of the rank of secretary and above of the government of Nagaland and headed by an officer not lower than the rank of a principal secretary, including the secretary in charge, which shall be known as the Naga PNG board, shortly the board. And then a team of officers, technocrats, economists, statisticians, academicians, experts in the industry, legal and business advisory, which will be the operational wing. So it's the operational wing, the board, and then the group of ministers, the MG.
Is a,
I think,
is
I
scope
think,
and ambit of
I think
the
if we can come to clause 7, rule 7, page 160,
Malod's
page 160
advertisement of zone.
zones.
Yes.
This means that the permit would include everything. Permit as such is not defined. 7.1 to offer these zones.
with the agreement MOU.
Where's the MOU in this one?
The permit only comes in the rule 16.
Yes, rule 16, Manoj.
It says fees.
Yes, Manoj, because if Manoj will have 15.2, 15.2 Manoj talks about the agreements.
Agreement.
Manoj, not just with the government. If Manoj will have 15.2 for a moment. It
With-
says besides the agreements mentioned in regulation 13.3 and 4 and regulation 14.5, immediately upon the signing of the agreement under regulation 14.5, another agreement shall be signed between the landowners and the company for handing over the land for access to the company for the requisite period with the village council concerned as witness for undertaking production operations.
Production operation.
So, Manoj, even the landowner. Look, there is, no, I'm not aware if an MOU was signed. This is the regulations, no? If not, we'll have no, the permits question may get answered in the regulations. No, the regulations start at page 143
143.
is the regulations. And through my experience, this is, it's usually the act, the rules, and then the regulations. But no, in this case, it's the act.
Regulation 3 also, please.
Yes, I'll just regulate.
9 says award of zone permits.
Yes. And then after that, 13 and 14 deal with how the land will be handed over. 10 also deals with permits. The restatement I see, it's a restatement of the assembly. And then they say that this is where we are deriving authority from. May also bear in mind, the act came in 1990. And the assembly resolution is in 2010, 20 years later.
Because why I'm asking is, you have to pay 76. The parent.
My lords.
Period for which prospective license may be granted or renewed.
Yes.
8.1.
The period for which a prospecting license may be granted shall not, in the case of mica, exceed 2 years. In the case of any other mineral, exceed 4 years.
4 years.
If-
Here the permit is 10 years.
10 years.
That is what
Yes.
I'm asking.
Yes. So to
If
that
it is-
extent, the
if it
rules
is-
are beyond.
Yes, if it is beyond,
Yeah.
and see rule two,
Yes.
subsection two.
If the state government is satisfied that longer period is required in the public interest to enable the licensees to complete prospecting operations, it may renew a prospecting license for a further period of 1 year at a time, but such further period shall not exceed 4 years in the aggregate.
So Act does not permit even the state government to grant permit beyond 4 years.
No, no,
I don't know, I have just.
yes, no, I fully see, Manoj, and I'll tell my difficulty in answering that question straight away, Manoj, because as far as this part is concerned, I'll have to, Manoj, look at it a little more deeply, because the prospecting license is not equal to a mining license.
That is what I am asking.
Yes.
What kind of
Yes,
right they have been given?
under the permit.
Yes.
Yes, Manoj, under the permit, to my understanding, Manoj, I'll have to check it out a little more deeply, Manoj, whether it's a prospecting right or a mining right.
It is a question simply said.
Absolutely.
If permit goes beyond the Act,
Permit is gone. No difficulty. Now, Manoj, if it's a prospecting permit.
then
I'm so
section 9. Section 9.
Is the mining lease,
If
Manoj?
it is mining lease, then it is 20 years.
Yes,
But if it is any other mineral, it is 4 years. So that is that I am.
that's a prospecting license.
And 9(2), mining lease,
Yes,
that is shall not exceed 10 years.
yes.
Now, where it falls? This permit granted to respondent number 7, under which it falls.
Manoj, whether prospecting or that, Manoj, I'll.
Because I think mining is, what is the definition of mining? Mining lease.
Manoj will have. Manoj, mining operations or mining lease, Manoj will find F.
F.
At page 68, Manoj 2F.
Hmm.
Manoj, may I read with minerals E?
Minerals.
Minerals.
Hmm.
Minerals means all substances which can be
Hmm.
obtained from the earth by mining, drilling,
Yes.
digging, drilling, dredging,
Petroleum.
hydraulicking, quarrying, or any other operation, and includes mineral oils, which in turn include crude oil, natural gas, and petroleum. Mining lease means a lease granted for the purpose of undertaking mining operations and includes a sublease granted for all or any of such purposes.
So minerals includes petroleum.
Yes, no, that's what the act says.
That act.
Yes. Now, Mulod, the moment it says that, no, it falls foul of 53.
No, I'm looking from another perspective.
Minutes.
If the permit falls foul of the act,
Yes. So, Mulod, the permit will go.
all these questions may be decided.
Mulod, now since my loads are,
Repeat academic.
Mulod, but since my loads have been seized off the rules and regulations. Yes.
Also the permit.
Or, Mulod, which is a consequence.
6 questions frame
Yes.
and the probable 7 question.
Yes.
But
But Mulod, if we can get away with answering 4, just question number 4. maybe- But is the permit a mining lease or is it a prospecting? What is exactly the nature of the permit? Where is the permit?
Page 146.
And the. Hmm. Yeah, I know. Notes to that extent, if notes will have a page 177 again, which is the permit itself. Is there any other document after permit which has been signed? If notes will see the permit, it says the permit will come into force so and so. Then it says will accordingly take effect on the signing of the documents. Permit is valid for 10 years, whereof the pre-production period shall not exceed 5. Now, the pre-production is the prospecting and development. Because prospecting would be finding the mineral. And then would be the development phase, and then would be the production
No,
phase.
but then that's why my brother asked you this question. If you come to this section 8 and 9,
Manoj,
it brings out a distinction. Prospecting license and mining lease. 8 and 9, there's a difference. That's why my brother asked you that question.
Manoj, what is the exact nature of the permit? Which my loads did put to me, that period for which the mining lease, and then it goes on to say, Manoj, 8 and 9. Prospecting license may be granted and renewed, and then the mining lease in 9. Now, Manoj will also see what Manoj the permit says. Manoj, the permit in at page 147, if Manoj will have for a moment. No, wait, the permit is for 3, 4. Manoj will have page 146 for a moment, which is Manoj the regulations. Please see at page 146. It says Manoj the rule 9, regulation 9 over there at the bottom. It says award of zone by permits. And then it says Manoj in 9, award of a zone for any category of operation to a company shall be by a permit issued by the state government, which shall be valid for an initial period of 10 years from the date of issue of the permit, which may be renewed every 10 years.
Which one?
146.
Manoj, awards 9, regulations below that page 146. My loads are with me.
Yes, but before that, regulation 7.
Classification of operations. All operations relating to petroleum and natural gas or both in every zone shall be categorized into the following. Pre-production operations,
Where
which,
is the pre-production operation?
yes, which
includes.
mean and include notes, so an exhaustive list notes. All operations like exploration, surveys, prospecting, trial production, etc., prior to the extraction of the first quantity of oil and natural gas, as the case may be, from the well for commercial purposes.
Whether it falls to section 8. This is the definition.
So pre-production operations.
Production operations includes prospect.
Yes,
Now, section 8,
of the Act.
Act, subsection 1, clause 2, Roman 2.
I'm just one moment.
Page 76.
Page 76.
We still have a problem every now and then when the
Okay.
machine hangs. Note 76(9),
76.
Section 9.
Subsection 1.
The
Clause 2. Period for which
mining lease may be granted shall not exceed 20 years.
no 8(1).
That is 1 year.
Oh,
is
I'm
2
so sorry,
years.
Manoj. I was reading 9(1). I'm so sorry, Manoj. Period for which prospecting license may be granted or renewed. The period for which a prospecting license may be granted shall not, in the case of mica, exceed 2 years. Any other mineral exceed 4 years.
Then
Yes.
subsection 2 also.
If the state government is satisfied that longer period is required in the public interest to enable the licensee to complete prospecting operations, it may renew a prospecting license for the further period of 1 year at a time. But such period shall not exceed 4 years in the aggregate, which means
Even
Manoj,
the
it
act
can
does
be
not empower.
so Manoj,
the state
4
government.
4 plus 4 then.
No, even the act does not empower the state government to grant a prospecting license initially
For
during
10
the
years.
period of 4 years. And it can renew
Renew.
up to another 4 years. Total 8 years.
4 plus
1 plus 1
1 plus 1,
plus
8
1.
equal to 8. Yes.
Now here, 146, pre-production operations includes prospecting. Section, page 146.
Yes, Manoj.
This is the definition,
Pre-production operations. Yes, Manoj.
right? Prospecting includes prospecting.
Yes.
Exploration, surveys, prospect. Then if we go to 163. Very not important, 177. The permit.
Yes. Now, Manoj, will
Clause
please.
4, this permit is valid for 10 years, whereof the pre-production period shall not exceed 5 years.
No, Manoj, what falls from my load is that this 5 could only be 4 and 4 could be extended to 5, but only subsequently, not right now.
If it,
Yes.
pre-production includes prospecting license.
Manoj, which
and
it
if
says.
And if it does not come under section 8.
We are not saying anything. We are trying to
Section-
understand.
Yes.
We are trying to understand. But if it is mining lease, then it can be granted up to 20 years.
It does seem, Manoj, that the term we used by my Manoj is not limited to that side of the bench. Even we are trying to figure out, Manoj, what exactly it means over here. Yes. So, Manoj, so to that extent, Manoj, the interplay between the act, the regulations and the rules, and what are the contours of the permit? Yes, Manoj, I fully follow, Manoj, and if Manoj will permit, Manoj, I'll Manoj figure out the connection amongst all of them.
Because 6 questions are there.
Yes, 6 questions are there. The permit is also there. Yes. But Manoj, as Manoj, even in this debate, Manoj, in those 6, Manoj, the probable 7th question is also important. It keeps coming up.
Different thing.
Yes,
But if
it keeps coming up, Manoj.
commercial production होता है ये तो पूरी
Production operation will be simple expected. This is from the very commercial purpose. Production just means mention. Production
company देखी पहले भी बोला है कि यहाँ तो एक बेसिक
actually key concept, key design. Mr. Balgopal. This will be a query to you also. You can also be prepared in the meanwhile. When your turn comes, you can respond to that. Because the permit is what is the scope of the permit? That will be a question to you also. So whenever your turn comes, you may address that.
Find the present submission is an act of metamorphosis. If you were to see the earlier submissions made by the learned ASD, they had almost concluded and he had only a small portion left. As far as Article 131 was concerned, it's partly argued. And then he himself suggested that we will not proceed. That is how we moved ahead. You know, it's going in different meandering methods. And trying to introduce certain things which are not even in.
But we can't help it.
This is very
Yes.
seriously objective in the time comes. You can make this up.
Yes.
So Manoj, I follow Manoj what falls from my load relating to the permit. And Manoj, whether the permit is within the act or outside of the act will be a question, Manoj. I'll address Manoj. No difficulty there. Yes. Now, Manoj, to the 6 questions that had been framed. And then subsequently, those 2 further orders. On 9th of December 2019, when entry 53 was specifically considered. And then on 14th of February 23, when the 2 questions relating to competence were framed. Now, relating to that, if will permit me, I would endeavor to start by looking at 371A and then trying to figure out that what does 371A really purport in terms of
That you already argued the last occasion you already argued.
No, it's not 371A. I did 131 on maintainability. But 371 has 2 aspects to it. One is where it merely is a defensive article which protects. I didn't touch 371A at all. I don't know if my learned, the learned ASG had done or not.
No, that was argued because the submission was, which you recorded, is that what you said, the no act of parliament would be in respect of religious and social practices 1, 2, 3, 4. And then it was submitted that there was an absolute right of the state and would have overriding effect of the other articles of the Constitution of India. That was the premise of the argument.
My arguments,
No, perhaps we are not written in sequence, whether it was you or Mr. Jain, we don't.
Because last time I had touched on 131
Hmm.
and I had dealt with that PIL on act and towards the end I had articulated what I will be covering next.
Yes.
And which was 371A, where I had said that it is essentially a defensive provision, which enables the Naga Assembly to identify and say that this act will not apply or this act will apply. But 371A in my humble submission, if will have 371 for a moment.
Yes.
Uh, 371A, it says special provision with respect to the state of Nagaland. Now, if I may just straight away right over here, just pause. We'll have to consider what special would mean, especially if were to see part 21. Notes where the part starts and it says temporary, transitional, and special provision. I'll just come to that, Manoj. Note special was added by the 13th Amendment. Prior to Manoj, Nagaland becoming a part, Article 371A becoming a part of the Constitution, it was temporary and transitional provisions. And only in 63 by way of the 13th Amendment was the term special introduced. Manoj, what will be the contours of special is something which Manoj will have to consider. Manoj, I'm right now restricting myself Manoj, to the competence part. So Manoj, I'll come to the other questions in a bit, but Manoj, right now only on competence. Now, Manoj, so therefore special is something which Manoj will have to consider. After that, Manoj, it says one, notwithstanding anything in this constitution. Now, Manoj, so the word notwithstanding is something which Manoj will have to consider because Manoj, the words are anything in this constitution. It doesn't say notwithstanding this constitution. So Manoj, whatever we wish to do has to be within the four frames of the constitution, the basic structure. It can be nothing. Notwithstanding can't be interpreted to mean it is dehosts the constitution. Now, Manoj, we are a separate republic and we are doing something which is not permitted by the constitution. I'll make good that submission, Manoj. So notwithstanding is again, Manoj, the scope and meaning of notwithstanding is something which Manoj will have to consider. And then it goes on to say A, no act of parliament in respect of 1, religious or social practices of the Nagas, 2, Naga customary law and procedure, 3, administration of civil and criminal justice involving decisions according to Naga customary law, 4, ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. And that's where note 371A 1A ends. Now, if Manoj will allow me to just break it down for a moment, Manoj, aside of the fact that special will have to be considered, notwithstanding will have to be considered, please see A. Manoj, it clearly says no act of parliament. So Manoj, the subject matter of the provision is no act of parliament. It is an act of parliament, Manoj, which is the subject matter of A. Now, Manoj, after that it says in respect of. So Manoj, the subject matter is limited to 1, 2, 3, and 4. And therefore, Manoj, before we consider whether a resolution is required at all or not, what this court will also have to decide is whether it falls foul of 1, 2, 3, or 4. Does the act of parliament relate to 1, 2, 3, or 4? If it doesn't, then I don't need a resolution. Then the act will apply de-horse mode. So the first thing Manoj will have to figure out is whether Manoj, the subject matter, which is an act of parliament, is Manoj relating to these 4 aspects. That's Manoj, as far as the subject matter is concerned. Please see after that, what does it say? Shall apply to the state of Nagaland. So, Manoj, the purpose of the section is the applicability of the act. Then it goes on to say, Manoj, unless the Legislative Assembly of Nagaland. So, Manoj, it gives who is the competent authority to decide. The Legislative Assembly of Nagaland. And then it goes on to say, by a resolution so decides. So it gives the methodology also on how a decision must reflect.
Just a moment. Mr. Jamir, in this, this permit is for the region of Peren. Right?
Not parent. It's an Oka district.
Wokha. Okay. And this region is covered under the Assam Land and Revenue Regulation as applicable in Nagaland?
No,
No. Okay.
Assam Land and Revenue Regulation 1886 is applicable in force only in Dimapur, Mauza, and the spirit of the regulation shall be applicable in the rest of the state.
Okay.
And Oka falls under the rest of the state.
Okay. Okay.
But Lordship, just sorry for interruption, just one point, one aspect which has bothered me, Lordship, during the course of the submission made by my learned friend. The testing phase issue to be decided in this matter, giving in view of the first order which my learned friend has referred to, that is 8/10/2015 and 14/2/2019, giving in view of all these orders with regard to the registration of the Somoto PIL, the issue, the crux of the matter to be decided is with regard to the provisions of 245, 246, and Article 371A. My learned friend has made the submission that state legislature do not have the power. It is not an enabling provision to make law. So we can submit on that point. And implication of 245, 246, and 371. Those provisions, how it should be applied, in what context it has to be applied, that will be relevant so as to decide this going by the merit logic. With regard to the maintainability, yes, that is another aspect. I will keep my reply at appropriate time. But the important issue is what is the lawmaking power, what is the power of the state legislature under 371A, and what is the power of the parliament under 371A. At the same time, what is the implication of Article 245 and 246 of the Constitution of India, and also the Article 254 of the Constitution. Those are the issues to be decided. I think that would be more relevant instead of going into the details. Now, I will just set an example. If a finding is arrived by this Honorable Court on the point that under 371A, the state legislature of Nagaland do not have any power to legislate. Maybe instead, we did not go into the permit or the place, whatever, because these are details. Once the power is not available, it is not necessary to discuss all these things because you do not have the power, so you have no authority to make the law. And if the state legislature has the power, has the competence to make the law, yes, then those issues will come. So the relevant issue will be to make submissions on the implication of Article 371A, which my learned friend is doing right now, and the implication of 245 and 246. So that the implication of 7 schedule of the Constitution will come. And we should also not forget the 9th judge judgment, where all the issues which this Honorable Court is questioning, asking, are all clarified in that 9th judge judgment. So this is a 9th judge judgment on so many issues, so many points, and it will be difficult for us to overcome that. So we should not forget dealing with this issue.
Okay.
Sorry for the interruption.
Okay.
So far permit is concerned, it is for Peren as well as Okha. There are two zone many
Peren, I remember. That's why I'm asking.
and Okha also.
Mukha also,
Well.
2 areas, and they are not covered by Assam Land and Revenue Regulation. Okay.
No, I fully suggest. I'm so sorry.
Yes. We'll take a short break and come back.
I'm so grateful. Lords, our pattern has been, Lords, we go till 1 o'clock. And then my Lords are generally, Lords have, Lords, separate benches. Today also it will be till 1, Lords.
Today is a full day.
It'll be
That's why
full
I
day.
keep only, we have kept only one item.
But in which case I'll have to, Lords, change my flights. I just wanted that clarity. So I'll just, Lords, off.
We also had a provision of spillover to tomorrow.
Tomorrow, Lords, I may be in a little bit of a spot, but, this subject.
It's okay, but
Yes.
mentally we are also.
I,
prepared for a spillover tomorrow.
I know, Lords, what falls from my Lords. In
Because-
fact, Lords, on the next occasion, if Lords will permit, Lords, we'll keep it for 2 days and then maybe,
Because where we brothers would be, tomorrow is another day.
yes. Yes. So, Lords, what fell from my learned friend, what my learned friend was arguing, Lords, relating to that 371 is really the main point.
I just want to clarify one thing. Parent you are not within the purview of this case, because the parent people did not file any case in regard to that. Only the
No,
Okaj.
we just wanted to have the idea. We were trying to understand the legal provision because in parts of Nagaland, Assam, land and revolution applies.
Yes, yes.
So we are just trying to have a mental framework as to whether these areas also fall within that.
Yes.
Because under the Assam Land and Revenue Regulation also, there's a chapter dedicated for prospecting
Right.
and oil and minerals. So therefore, we are trying to have a mental frame, what do you call, thought process with regard to exclusion. If that's not there, then we don't apply a mind
Yes.
in that particular field.
So far,
Because-
this case, my lord, is relating to Okajun only.
No, that's okay. That's why we are trying to understand.
Right.
If the Assam Land Revenue Regulation does not apply, then once where we don't have to apply a mind.
Right.
There's a dedicated chapter for extraction minerals, oils and minerals.
Right.
So, Lord, what my learned friend mentioned, Lord,
Because
about.
then the legislative, you see, there will be another aspect. If that applies, even divorce the act and rules, still under the Assam Land and Revenue Regulation also, the state would have power. So we do not have to address that point at least.
Lord, what my learned friend mentioned about, Lords, this, let's say the sequence in which, Lords, the arguments, Lord. So, Lord, as I mentioned last time, Lord, I'll just lay out, Lord, my sequence, and then, Lord, the first one is, of course, going to be 371A. And my first endeavor, Lord, is going to be to demonstrate to my lords that 371A does not confer any legislative competence on the Assembly of Nagaland. And therefore, my lords, the act, the regulations, and the rules which have been framed are all foul of, lords, entry 53. And therefore, my lords, the act, the regulations, and the rules must go purely on the ground of lack of competence. Now, my lords, the other aspect, on the flip side, the mirror argument. Now, the other aspect which my lords will have to consider, which is the mirror, is, my lords, will the Act of Parliament apply? Because, my lords, can't be left in a vacuum. We have the Oil Fields Act, we have the petroleum rules, the PNG rules, everything is in place. whether those will apply or do those central acts fall foul of ownership and transfer of land and resources. If those are to hold that yes, they fall foul and absent a resolution from the Naga Assembly, those acts will not apply. Then there is a little bit of a, so to say,
That is why my esteemed brother had put that question to you to understand what is land, what is resources.
absolutely.
That it's-
And I'll come to that. That part we'll have to answer. There are two parts over there which we'll have to consider. One is, of course, land
By
and
your own way of.
yes, I'm just, since the question came, I'm only saying, land and resources will be one part. But 4 actually, says ownership and transfer of land and resources. So, land and resources, we'll have to figure out whether land and resources, the minerals, oil, everything will be covered under land and resources. Then, we'll also have to see whether the central acts are dealing with ownership and transfer, or are they looking only at regulation and development in pith and substance, and have no desire to deal with ownership and transfer. So, while it may be land and resources, if it is not ownership and transfer, then I don't fall foul of 4. Because 4 clearly says ownership and transfer of land and its resources. So both the things are unnecessary. It is not sufficient that I am dealing with land and resources, therefore I am falling foul. Both the conditions are necessary. It must deal with ownership and transfer of land and resources, then I fall foul. If I'm able to satisfy my loads that I'm not dealing with ownership and transfer at all, I'm only looking at regulation and development in pith and substance, then I don't fall foul of 371A. And therefore, there is no need for a resolution. The Act will apply. But the first point of order will be competence, because we are dealing with the Naga Act, regulations and rules. So, coming back to 371A, as I had mentioned before the break, we'll see 371A is clearly a negative injunction. It starts by saying no act of parliament will apply. And then it gives the manner in which the act can apply, who can take a decision about its application, and what is the method by which that decision will express itself. So 371A gives all of that. In my humble submission, 371A, I don't know, nowhere I couldn't find any words in 371A 1A which say the Naga Assembly will be competent. And over there, my lords will have to, which will be the next part of the argument, my lords will have to consider the articles under which competence is granted and the manner in which competence is granted. This is just to clarify there is a particular choice of words in the Constitution of how the framers have chosen to distribute competence and how they've worded those articles. My lords will have to consider that, just to starkly point out the absence of those words in 371A. So this assumption of competence is completely wholly misplaced. There is no competence with the Naga Assembly to acquire a field which they do not exercise any competence over. Interestingly, in this part of the argument, we'll have to consider. I'm so sorry.
Whether an act of parliament in respect of ownership and transfer of land and its resources exists.
I'm so grateful for that question, because ownership and transfer on one side and land and its resources find themselves distributed over the 3 lists completely. So, Mlod, there's no single act which deals with Mlod's ownership and transfer of land and its resources. There is no single field in list 1, 2, and 3 which says land and its resources and says ownership and transfer. So, Mlods are aware. Mlods, in list 3, we have the Transfer of Property Act. Now, Mlods, in list 2, in list 1, we have Mlods the oil fields in 53, industries in 52, mines and minerals Mlods in 54. Now, in list 2, Mlods, we have land in 18, agriculture in 14, and Mlods, then we have in 23, we have mines and minerals. In 25, we have gas and gas works. So, Mlods, everything is completely distributed, and every entry, as Mlods have held time and again, every entry has to be given its space and meaning. It can't be that one entry or one word will override everything else, and which is where Mlods, the meaning of the word notwithstanding in 371A will come into play. But I hope I was
Yes.
clear. Yes. Mlods, we'll have to go through each one of those entries to see how the distribution is, because Mlods, in some cases, the distribution is concurrent in the list 3. In some cases, the distribution is with the state, but the parliament has the ability to transpose it to list 1. And Mlods, in some cases, it is in list 1, which means that the state has nothing to do with it. Now, Mlods, 371A can't, in my humble submission, Mlods, because of the word notwithstanding, Mlods, change the basic federal structure of the constitution and Mlods, transpose list 1 to itself. That concept, Mlods, of a reverse transposition doesn't exist.
But you see, if you are looking at this Oilfield Regulation Act
Malods.
1948, then we find that everything which is required for the exploration and the extraction of oil will be under this act. And therefore, the protection of the land and ownership as well as its resources, so far as the state of Nagaland is concerned, will be always subservient, because this doesn't give any primary effect or the primacy to the ownership of the land and its resources,
Mlods.
because this
Mlods,
This
I'll
is-
take my Mlods, Mlods, there will come a stage, Mlods, when either today or the next time, Mlods, when we'll go through this act clause by clause. Mlods, we'll have to, Mlods, for the reason that, my Lords, we'll have to consider whether this act relates itself to regulation and development of Mlods an oil field, or does it deal with ownership and transfer of Mlods, the land and its resources, means the site, or Mlods, what is found on the site.
it covers.
Mlods, that Mlods will consider. In my humble submission, Mlods, it doesn't. And the Supreme Court has Mlods severally in several judgments said that when it relates only to regulation and development, it doesn't concern itself in pith and substance with ownership, and therefore it doesn't Mlods deal with ownership and transfer. And Mlods, I Mlods have been using that term since morning. Mlods will have to consider it in pith and substance. There may be an incidental encroachment, but that will only be incidental, not with a desire to own or transfer or Mlods to regulate that ownership and transfer. It will only be a necessary incidental absolute Mlods encroachment for a very limited purpose, so that the regulation and development can take place. Mlods will find in the Oilfield Act and the PNG rules, they'll be extensively Mlods we've dealt with, and when I take my notes through that, Mlods, extensively there are clauses, sections, Mlods, rules which deal with how the site is to be Mlods worked, how the
but six-
stakeholders at the site have to be
6A
protected.
But 6A
Mlods.
refers to the payment of royalty in respect to the mineral oil mined.
Yes. It does. That is Mlods, please see, there are two
And
possibilities. Mlods.
7 also.
Yes.
to Central government by notification make rules for the purpose of modifying or altering the terms and conditions of the mining lease granted.
Mlods will also have to consider, Mlods, if I could just, Mlods, my Lords will also consider Articles 294 and 297. Because 297 deals with the economic, exclusive economic zone, the coastal waters around India. And that 297 clearly says everything vests with the central government. Nothing vests with any state government, even though the coastal waters are touching the state government. Everything vests with the central government. 294, on the other hand, absolutely recognizes private rights over minerals and land. So, there are judgments of the Supreme Court which have said that if I own a land, then the minerals on that land belong to me. Now, royalty in that case, or assess to me, or compensation is what my lords will have to see. Because I'm not looking at depriving anybody of their ownership or transferring their rights.
Because that can be answered in a very simple example.
My lords,
Let us say that X owns a plot of land.
my lords,
In that land, sand can be attracted or earth can be attracted. It's a mineral.
my lords.
So therefore, he will get the royalty or whatever sharing he desires. But when it comes to oil, which is below, that's why the last day the question was, if we understand the terminology, then it will be easy to follow the rest of it.
Absolutely. Milord. And we'll come to that, because as I had said last time also, Milord, extraction of oil, aside of the great competence which the people of this country have in every sphere, requires a huge amount of capital. Requires a huge amount of capital. And I'm not saying, Milord, that this is going to be the largest find in the world. I'm not saying that. Even for a small field, it requires a fair amount of capital. Who has the capacity to put in that capital? An individual landowner, a state government. Finally, after 40 years of independence.
People have that much of cash in hand. A
Uh,
year back,
unfortunately-
we are only a year back.
Yeah.
How much crores was extracted from a house?
Yes, I was just going to say, unfortunately, we are not those people.
No, we don't know.
Yes,
May God bless everyone with that amount.
yes, may God. Just in the bank instead of the house. Yes. So, we'll have to see at that point of time, who's going to put up the capital. So, there are again, I'll address three possibilities. Where, if it's a small mining operation, the private landowner will say, I'll do it myself. But, does that mean that he is beyond any regulation? Can he exploit the land to the derogation of the land itself? Can he exploit it in a manner which destroys the environment around it, or the ecology or the ecosystem around it? Or is he subject to some regulation, not to transfer or ownership, but to just regulation? Will he be subject to that? If he doesn't have the capacity, scenario 2, then if he ties up with a private party, between the two of them, are they able to exploit it, dehorse any regulation? Or is the regulation the underlying theme where the government is saying you want to do whatever you do, but you still have to comply with the law? You cannot, I ask myself the question, coal, easiest thing, open cast. Is it possible for me to be outside of the Minimum Wages Act, which is also regulation? Is it possible for me, to be outside of whatever legislation the state has made to protect, the most basic stakeholders in a coal mine, the miners, their safety, their health, their regulation relating to medical, children's education? Can it be
For that, there are separate acts.
acts? And
But
which
it
is why I'm
not under
saying,
the regulatory provision which they are controlled.
yes. Now, over here, I am, therefore, there are separate acts dealing with the various stakeholders. My acts are dealing with the regulation of developing the field. That you cannot develop it in a manner which is so exploitative that it causes harm to the environment. It has to be done in a systematic, it has to be done in a sustainable manner. It has to be done in a manner, and after everything is over in 20 years, you will restore the site back to its original form. Now, that's all regulation. We'll go through the act, and we'll find out whether, which part of the act do they find offending. Because, when they say that 371A(1)(4) is being offended, there has to be some reason on that. And as we saw, my lords, there is nothing in the resolution which says what they found offending. The resolution merely says that anything relating to transfer and ownership of land and its resources will not apply. Now, whether this act falls foul of it, somebody will have to, my lords, take a decision. The state government obviously has not taken that decision. Neither has the Legislative Assembly. And which is why I said, my lords, all the easy things come up to this honorable court. Whether the act falls foul of it or not is not going to be a very difficult question, which my lords will have to concern themselves with. Yeah. The landowner himself can't go and just simply start operating a mine or a oil field. Even he's subject to regulation. Correct. So, my lords, that will be my flow of arguments as far as 371A are concerned, Lord. And of course, I will be citing law also, Lord, along the way. Lord, may I start, Lord, with the word notwithstanding? Yes. Lord, notwithstanding, Lord, in the pleadings has been, Lord, put on a pedestal where, Lord, it overrides the entirety of the Constitution, Lord, to the extent that it overrides 245, 246, and simply transplants the 4 subjects, to, so to say, in the state list, to the exclusion of the union. Now, Lord, what exactly are the contours of this, notwithstanding anything in this Constitution? Lords, may I just invite my Lord's attention to 371F for a moment, Lords. If Lord will have 371F, Lords, that is a special provision with respect to the state of Sikkim. And it has exactly the same opening sentence. My Lords are with me. Lord, it starts by saying 371F, special provisions with respect to the state of Sikkim, notwithstanding anything in this Constitution. And then, Lords, they've laid out the various fields. We don't need to concern ourselves with the fields, Lords, only with the word notwithstanding anything in this Constitution. Lords, may also bear 2 things in mind over here. I'm so sorry. I'm so sorry. Those again on that logistical issue, those I've just been instructed. Today is Raksha Bandhan. I'm not blessed with a sister, but I believe some of us are. So they may be that, and I believe the timing is that till lunchtime there is Bhadrakal today. So after lunch is when the ceremonies are supposed to be. So I may take some leeway in the afternoon sometime. Now, would recall Sikkim was not a state formed out of India. Sikkim was a result of a merger of a kingdom with the state of Union of India. Now, given that status, where a set of people, a land, entire population was being ceded to India, or was surrendering their sovereignty to the Union of India. In that context, the term had been used, notwithstanding anything in this Constitution. So this was when there was a monarch there was a relationship which the monarch had with his subjects. There were certain rights, obligations, duties which were predating the merger. And my lords, that set of obligations, rights, entitlements between the two was set. Now, my lords, those were all surrendered and they came to India. And then, my lords, they had all these protections. In those circumstances, I'll just take my notes through this judgment of R.C. Podial. I'm sure my lords have had reason to, study it earlier or consider it earlier. Notes where it is categorically held that notwithstanding anything in the constitution would not mean notwithstanding the constitution. It cannot be that the amending power, when they inserted 371F as they did 371A, the amending power can go beyond the constitution. It has to be within that famous basic structure constraint. While the provisions of the constitution are subject to this particular clause itself is subject to the constitution. It is not dehorse the constitution. Now, Nagaland in turn was a result of a state being formed as a result of that 16-point agreement, 13th amendment within the territories of India. There are several judgments in this. This is not one.
Page 22 is where.
Yes, so in that background, may please bear in mind because I'm taking one liberty here, rather than take my lords right now through all the the historical background relating to the Hydra Act, the Hydra Agreement, and the 16-point agreement, and then the 13th constitutional amendment, then the Nagaland Act. Would permit me that I'll do that when we are dealing with ownership and transfer and land and resources, because that's where the crux of it will be.
You were referring to?
Yes, I'm referring to this place. That page 22, my lords will find cordial. Of this bundle. This was a constitution judge bench judgment. There were three separate opinions. There were three separate opinions. If not, we'll have the very first page, which is at page 22. I just wanted to point out the judgment that I'm reading, the opinion that I'll be reading. My Lord Justice Sharma, L.M. Sharma, the learned Chief Justice.
A dissenting note.
Was a dissenting note. Yes. My Lord Justice Venkachalaya.
Because in the original judgment, this is not the sequence.
I'm sorry, no?
In the
original judgment, this is not,
the sequence.
Yes. It's actually my Lord Justice Venkachalaya as he was then, and Justice Verma and Justice Jayachandra Reddy. My Lord Justice Venkachalaya writes for the three. And then my Lord Justice.
Because that is why I always have a question. That although they have a trademark for the, what do you call, trademark for the head notes and all.
Yes.
But can a journal change the sequence of the original judgment?
But I guess they did it by order of hierarchy, Manoj, precedence, Honorable Chief Justice being the
To
first.
change the original sequence of the judgment, that's something which,
That is a little odd.
in the original judgment, there may be 20 paragraphs, and then when we find in the SSC, it can be 24 paragraphs.
Yes, no, that I find quite a lot that they break paragraphs per there. That's a little odd. That's a little odd.
Because you see, I'm not speaking for the bench, I'm speaking for the young juniors who are there at the bar. Maybe they may not be able to afford, say, a costly journal.
No.
And then they have the original version from the Supreme Court website or from from a less costly, what do you call, subscription
Subscription.
of the judgments. They won't be able to follow when this somebody like you are referring to a SCC.
No,
They will not be able to follow which paragraph where.
absolutely. No, that can happen. That can happen.
So that's why perhaps the neutral citation is the one of the best solutions the Supreme Court has come up.
Yes.
Neutral citations, at least you get the original version.
Yes. And no, in fact, now they are thinking of how to make it reportable in the sense that that will be the citable judgment and you can cite that and it will be the common citation for everybody. So if they are able to do that, that should be very, very helpful.
Well, it is reported in the SEC 1994, Supplementary 1, Supreme Court cases 324, which my learned friend is referring to.
Yes.
This is 1994.
Supplementary 1, SCC 324.
24.
Yes,
Yes.
324. Yeah, that's absolutely right, Mr. Namin.
Refer this instead of referring to so many twisting the background. Everything is
He doesn't like my arguments. Yes. So if Manoj will have, in this judgment, my Lord Justice Sharma is the dissenting note. My Lord Justice Venkatachalaya, Justice Verma, Justice Jayachandra Reddy is the common opinion written by Justice Venkatachalaya, and Justice S.C. Agarwal is the concurrent judgment, which is only in some part dissenting. But the relevant opinion is the majority
Yes.
judgment. And if will have straight away, I'll go to that straight away. Okay. Nodes will have it at page 65. No, 64 this is just after nodes para 57. Para 57 is the last nodes para of my Lord Justice, the Honorable Chief Justice's opinion. And then at Placetum G, and H, between G and H, it says my Lord Justice Venkatachalaya for himself and Justices Verma. and
Javed,
H.
it is page 366.
No, 366 in the SCC.
It's
The
it's not
SCC page, Mr. Jamir, is 366. Yes.
right. Yes.
Yes. Manoj will have the relevant part where Manoj, the issues have been framed and the principal question has been laid out. At page Manoj 373 internal, para 85. So I'm concerning myself with the word notwithstanding and not with the dispute, which was the distribution of the electoral franchise there, where there was a Sangha seat, and then the Bhutia Lepchas had been given a specific number of seats, which was in the challenge, it was against the one vote, one person, basic constitutional mandate of the Indian Constitution. The court, of course, negated that. If will have para 85. It starts by saying, on the contentions urged in support of the petition, the points that fall for consideration are the following. Notes, may I say, the 1A is the relevant one. It says whether the questions raised in the petition pertaining to the terms and conditions of accession of new territory are governed by rules of public international law and are non-justiciable on the political question doctrine. Now, Manoj, while answering this question, the court has dealt with the term notwithstanding notes. If notes will, notes allow me. Notes, at page 374, contention A is considered.
Yes.
Yes. Notes, the relevant part of it, notes, in the interest of time, would be para 18.9. My notes are with me? Para
Yes.
89. The principal questions are whether there are any constitutional limitations on the power of Parliament in the matter of prescription of the terms and conditions for admission of a new state into the Union of India. And if so, what these limitations are. Articles 2 and 4 of the Constitution provide Parliament may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. 4. 1. Any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law and may also contain such supplemental, incidental or consequential provisions, including provisions as to the representation in Parliament in the legislature or legislatures of the state or states affected by such law as Parliament may deem necessary. No such law shall, as aforesaid, shall be deemed to be an amendment of the Constitution for purposes of 368. In Article 4, they came out with the Nagaland Act of 62, which amends the fourth and second and fourth schedule, mentions Nagaland as the state in the list of states. But notes 2, and as far as 2 is the important one, which says may by law admit into the Union or establish new states. Now, Sikkim was admitted, while Nagaland was established. That's the only distinguishing feature. Now, may please see 91. Can the Parliament, in imposing terms and conditions, in exercise of power under Article 2, stipulate and impose conditions inconsistent with the basic and fundamental principles of Indian constitutionalism? Or is it imperative that the newly admitted states should be treated exactly similar to the states as at the time of the commencement of the Constitution? If not, what is the extent of the permissible departure and latitude? And do the conditions in clause F of Article 371F as expressed in the electoral laws as applicable to Sikkim go beyond these constitutionally permissible limits? These are some of the questions. Now, this is exactly what we are dealing with. When they carved out Nagaland and they put the word notwithstanding, could they have imposed limitations or given powers which go beyond the Constitution? Is what my lords will have to consider. 92. The learned Attorney General for the Union of India and Shri Parasaran sought to contend that the terms and conditions of admission of a new territory into the Union of India are eminently political questions which the court should decline to decide as these questions lack adjudicative disposition. This political thickets doctrine as a restraint on judicial power has been the subject of forensic debate, at once intense and interesting, and has evoked considerable judicial response. We are not really concerned with that question. So I'll skip 93, 94, 95, 96, 97. And I'll come to 98, where the court summarizes this political question debate by citing an Indian judgment. Our court has received and viewed this doctrine with a cautious reservation. In A.K. Roy, my Lord Justice Chandrachud recognized that the doctrine, which was essentially a function of the separation of powers in America, was to be adopted cautiously and said, It must also be mentioned that in the United States itself, the doctrine of the political question has come under a cloud and has been the subject matter of adverse criticism. It is said that all that the doctrine really means is that in the exercise of the power of judicial review, the court must adopt a prudential attitude, which requires that they should be wary of deciding upon the merits of any issue in which claims of principles as to the issue and claims of expediency as to the power and prestige of courts are in sharp conflict. The result, more or less, is that in America, the phrase political question has become a little more than a play of words. There is further recognition of the limitation of this doctrine in the pronouncement of this court in Madhav Rao Jiva Rao Scindia and State of Rajasthan versus Union of India. It is urged for the respondent that Article 2 of the Constitution empowers the Parliament by law to admit into the Union new states on such terms and conditions as it finds fit, and that these considerations involve complex questions of political policy and expediency, of international relationships, of security and defense of the realm, which do not possess and present judicially manageable standards. Judicial response to these questions, it is urged, is judicial restraint. Now, I'll read 101. The validity of Clause F of Article 371F, introduced by the Constitution 36th Amendment Act, is assailed on the ground that the said clause provides for a reservation which violates one person, one vote rule, which is essential to democracy, which latter is itself a basic feature of the Constitution. The power to admit new states into the Union under Article 2 is no doubt in the very nature of the power, very wide, and its exercise necessarily guided by political issues of considerable complexity, many of which may not be judicially manageable. But for that reason, it cannot be prededicated that Article 2 confers on the Parliament an unreviewable and unfettered power immune from judicial scrutiny. The power is limited by the fundamentals of the Indian constitutionalism, and those terms and conditions which the Parliament may deem fit to impose cannot be inconsistent and irreconcilable with the foundational principles of the Constitution and cannot violate or subvert the constitutional scheme. This is not to say that the conditions subject to which a new state or territory is admitted into the Union ought exactly to be the same as those that govern all the states at the time of the commencement of the Constitution. Now, 102 directly deals with the non-obstante clause. It is, however, urged that Article 371F starts with a non-obstante clause, and therefore other provisions of the Constitution do not limit the power to impose conditions. Article 371F cannot transgress the basic features of the Constitution. The non-obstante clause cannot be construed as taking Clause F of Article 371F outside the limitations of the amending power itself. The provisions of Clause F of Article 371F and Article 2 have to be construed harmoniously, consistent with the foundational principles and basic features of the Constitution. Whether Clause F has the effect of destroying a basic feature of the Constitution depends, in turn, on the question whether reservation of seats in the legislature based on ethnic groups is itself destructive of democratic principle. Whatever merits be of the contention, it cannot be said the issues raised are non-justiciable. I'll just pause here for a moment before going to 103 and 4. So what the court categorically says is, notwithstanding the Constitution. It is within the basic framework of the Constitution. This was when a state was being admitted. In our case, there is no such admission. It is a state which is being carved. So it has to be closer to the states as they were at the time of the Constitution being adopted, rather than the new state which is being adopted, at which time the political considerations may be very different. So therefore, notwithstanding over here would not give a passport, so to say, that we can trammel upon the basic features. Which part trammels upon the basic feature, I'll come to. In my humble submission, this entire theory that the subjects switch from list 1 to 2 is, it goes to the very root of federalism, which is the basic feature of the Constitution. Because what this switch theory does is, it says that by putting in an article without any specific words on an assumption, a state can acquire competence relating to entries of list 1. That cannot be accepted. Not without the clear intention of Parliament being there, where Parliament grants competence and says, yes, as far as these subjects are concerned, the state will have power. No such words in 371F. I'll just demonstrate that. So, whatever the scope of notwithstanding, which the other side may wish to argue, the Supreme Court in a constitution bench judgment has clearly said it can't be beyond the Constitution. It has to be within the force boundaries of the Constitution. And the basic feature of the Constitution cannot be tinkered with. Now, may please have 103. In Mangal Singh versus Union of India, this court said, power with which the Parliament is invested by Articles 2 and 3 is power to admit, establish, or I'm sorry. Yes. Power to which the Parliament is invested by Articles 2 and 3 is power to admit, establish, or form new states which conform to the democratic pattern envisaged by the Constitution. And the power which the Parliament may exercise by law is supplemental, incidental, or consequential to the admission, establishment, and formation of a state as contemplated by the Constitution, and not power to override the constitutional scheme. So that's the limitation on the amending power itself. That by exercising the amending power, you cannot override the constitutional scheme, which in our case is federalism, the distribution of legislative powers across the 3 lists. Even if clause F of Article 371F is valid, if the terms and conditions stipulated by a law made under Article 2, read with clause F of Article 371F, go beyond the constitutionally permissible latitudes, that law can be questioned as to its validity. The contention that the vires of the provision and effect of such a law are non-justiciable cannot be accepted. Contention A is therefore rejected. Notes on the political question, but while doing so, they also dealt with the question of what will be the contours of notwithstanding. Now, in my very humble submission in 371A, the use of the word notwithstanding does not give a free passport to write roughshod over the Constitution itself. Whatever, is the understanding, the contract of the Indian Union with the people of Nagaland is subject to and within the 4 boundaries of the Constitution.
Please come to the paper book 143.
My notes. Regulations rules.
Yes. The second paragraph.
My notes. I'm grateful, Manoj. The second paragraph reads thus, Manoj, whereas the Union of India, while replying in Lok Sabha to a question raised on the issue on the 10th of March 2011, declared that the state of Nagaland has the power to frame rules for governing matters relating to petroleum and natural gas within the territory of Nagaland. I'll take my notes to that answer. My primary contention over here is, an answer in parliament is not law. It may be indicative of the thinking of the government of the day, but it is not law. And in any case, it can't amend the constitution. That, there is a full process in parliament. It can't be without that. Now, this particular answer was given basis, the opinion of the Ministry of Law and Justice, which opinion, was not accepted by the Ministry of Home Affairs, and which finds itself in that letter, which my lords had so kindly last time pointed out, where the concerned minister had written to the Chief Minister of Nagaland and said that your acts are violative of the Central Act, please, and of the Constitution, please withdraw them. So, this particular paragraph would in no manner confer any competence. This can't be the manner of conferring competence. I'll take my lords through the other articles, how competence is granted. This could at best be termed as an acceptance, which I'm not conceding to. I'm not conceding to. But their best case could be that the government, the union government, by making such a statement in parliament, had given some kind of maybe a acquiescence, a waiver, or something of that sort. But in an answer to a unstarred question, that can't be competence. That can't be competence. That can be acceptance, maybe. But I'm not conceding, as I said. But it can't be the grant of competence. The source has to be explained somewhere.
No, because then the supplementary query would be, what is the authenticity of a statement made in the House of the Parliament?
It is based on an opinion, which opinion was not accepted by the Ministry of Home Affairs. Now, in that window period, when that opinion was taken, the question came and the Home Affairs said, no, we are not accepting it. This kind of a thing can happen. Now, further supplementary question, if it does come, that was Parliament then informed that there is a change in stance? That I'll have to check, but I don't suppose, I will have to check, but I don't think, But the MHA clearly said no.
But MHA is assuming that the MHA gave this sort of opinion, that would not be.
That too is not binding. That means my lords will decide. Ultimately, lords, we all may have opinions. The final determinative opinion is what falls from the court.
No, which comes from the concerned ministry, which is the Ministry of Petroleum.
At best, contemporaneous exposito. That is the current thinking, lords. But that would be an argument, lords, advancing the side of the other side. It will not be, lords, in derogation of my argument that there is still no competence. Ultimately, as lawyers, many times our opinions are accepted. Many times, they are controverted. There may be a parallel counter opinion also. But an opinion by itself, doesn't become law, much less a constitutional amendment. And an answer in parliament will not be an amendment to the constitution or granting powers beyond what the constitution says.
I don't know, because what would come from Because since we did not have that experience being there, being a part of deliberation, we can only we are just thinking aloud. You see, to a question about the competency,
Manoj,
in the parliament, a question is raised, a reply is given.
Manoj.
Now, that means some value must be attached to that, because that was a question relevant to the fact and issue.
Manoj.
And therefore, when I fall back to my alma mater, which is CPC, they said it's, and the evidence act, it says it's an admission.
Manoj.
So therefore, once there is an admission and there's a presumption attached to the statement made in the parliament, which is not controverted, not withdrawn, then to come out from that admission,
Manoj will also then have to consider privilege.
hmm,
Manoj will also then have to consider privilege. Manoj, privilege.
privilege. No,
Yes.
that is a privilege. You see, I have my own reservations. In privilege, the privileges are two kinds. It's a civil and it's criminal.
Manoj.
The privilege is 132 or 133, whatever it is,
Yes.
which is that.
Yes. Manoj.
Somewhere there. So the privileges are two kinds, civil privilege, sorry, and
And criminal,
a criminal. So the civil privileges is saved, not the criminal.
not the criminal.
So if
No,
there's
but
a
this has
criminal
nothing to do
incident,
with criminal.
no.
So that
So,
extent. Yes. Yeah.
So that means that statement
But no,
is not
it'll have to be
justiciable.
it'll have to be taken holistically. Because after that judgment, after
No,
that,
not that. You see,
after that
once
statement.
once you are referring to that privilege,
Manoj,
privilege is that for that statement, you can't be held up for defamation or for any other wrong
Yes,
statement. Civil
yes.
consequences will not follow.
Manoj.
But we are
But
not on.
Manoj, would it be amounting to admission?
Yes.
On the other side, would also be a question Manoj will have to consider. And Manoj, holistically in the sense of
Because
that
this
there
is a
is
question
nothing,
raised. This is a question raised in which time?
no, this is in 2011.
2011.
Yes.
So then the act is already in place.
10th March 2011.
So therefore
The
this
act was in
is-
place, but the rules and regulations were not there.
So
2012.
therefore the rules came thereafter.
The rules came thereafter. Because no, they are seeking, the rules are seeking their source. The assembly resolution was there, which is 2010. The rules regulations were not there. No, I'm just no, in assistance of court. No, I'm not here to at this moment no, not arguing this case or that case. I'm just assisting the court. No, the dateline is in 2010. The resolution came. 2011 the question came. 2012 the
This was
rules and regulations came. 2013 that letter came, where the minister said that no, this is not acceptable. So Manoj will have to view it holistically as Manoj will.
We'll go to that sequence again.
Yes,
Note it down in our notes.
yes, yes. But Manoj, before I go to that sequence, Manoj will permit me, Manoj, just to take my loads through 371.
No, you go through your preparation, but
Yes.
we'll note it down
This
for
question,
reference.
Manoj, we'll deal with. Yes. So grateful, Manoj.
Page. Page.
Yes.
Yes, may please. So, Manoj, the question which we parted with, Manoj, which fell from my loads relating to that parliament question. So, Manoj, we've done that research. There are judgments which clearly say that get the answer to a question. Even an affirmative speech made by one of the ministers carrying out a promise or a proposal does not tantamount to promissory estoppel, and
Is
it
it?
can't be.
Very good.
That clearly says that, Manoj. So that part, Manoj, I'll deal with, because Manoj, I also checked out with my learned friend, and he mentions that while this question was answered in 2011, Manoj, after that, it seems that in Parliament also a rectification was made, and Manoj, the answer was recalled. But I don't have that with me right now. So, Manoj, I'll put that to my lords next time. Manoj, I'll bring it on record also, Manoj, to address this part. Now, Manoj, we were at the part where, Manoj, after, uh, in my humble submission, Manoj, having dealt with, if Manoj will permit me to go back to Manoj, my flow of arguments, where Manoj, I had said that 371A, Manoj, we've dealt with the notwithstanding part. Manoj, the special part I'll deal with, Manoj, when I'm dealing with the second part of the argument next time, which is relating to ownership and transfer, land and its resources, Manoj, to show that historically also what the intent was when Manoj, this phrase came in. So, Manoj, notwithstanding we've done with. Now, Manoj, what we have to deal with is 371A, 1A. If Manoj will have that for a moment. Now, Manoj, I guess, Manoj, in today's afternoon session, Manoj, will be only on the realm of interpretation of 371A, 1A. Load the with me. It starts by saying, Lords, notwithstanding anything in this constitution, Lords, which I've already demonstrated, Lords, can't be dehorse the constitution. It has to be within the framework boundaries of the constitution. A, no act of parliament. So, Lords, the subject matter is act of parliament. In respect of, Lords, for a moment, we leave those four Lords entries aside. No act of parliament in respect of 1, 2, 3, 4 shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. Now, Manoj, as I read 371A1A, in my very humble submission, Manoj, I do not read any word or combination of words which even remotely suggests that absent the resolution or in the resolution, the Naga Assembly can assume competence. There is nothing in the article which suggests even remotely, that this is an article conferring or granting competence. This is an article, notes in the second part of my arguments I'll demonstrate, which is a purely defensive article in terms of the understanding of the Union of India with the people of Nagaland relating to their special status to protect the Naga way of life. It is not in any manner an affirmative, ceding of competence by the union or surrendering of any rights of the union. Only to the extent that you will, as far as these four topics are concerned, the Naga Assembly will have the ability to say these acts will not apply. Now, the consequence of that could be, as we will see in the latter part of the argument, that there are some elements which will fall in list 3. So, if the Union Act is not applying, then of course, being in list 3, the Naga Assembly has competence. Naga Assembly can regulate. Competence is inherent, then if it's a list 3 item. We'll see in list 2, where any element is transposed to list 1. If that is stopped or which is disabled, that it will not apply to Nagaland, then of course it's an element in, it's an entry in list 2. The Naga Assembly has competence, they will legislate. But what happens in list 1? If it is an entry which is solely exclusively to the competence of the union, the Naga Assembly has the ability to say that yes, this act will not apply. But that does not mean, absent any express words in the article itself, that there is going to be a switch of competence. And since the constitution, my learned friend will argue, abhors a vacuum. So the vacuum is assumed to be filled by a transfer of competence. That's like a very big assumption. And in my very humble submission, I'll demonstrate which goes to the root of the basic structure of the constitution. And there is no space for this kind of an assumption as far as 371A is concerned. Now, whether 371A, 1A is to be read in a narrow manner because it creates an exception. So therefore, it will be a strict interpretation, or it is to be given a liberal interpretation because it is to protect the Naga way of life. That's something which will consider in the second part of it. At the moment, I'm addressing only the competence of the Naga Assembly. There is nothing in this article which would even remotely suggest that there is competence or any assumption of it. Now, to that extent, before I go further, I would like to cite a few judgments which relate to the interpretation of the constitution and how the constitution entries are to be or articles are to be looked at. If will have synthetics and chemicals, it's not in that bundle. I'll hand it over notes. This is a 7-page judgment, as my lords are aware, which related notes to the question of potable liquor notes or alcohol for the consumption of humans, as they would say. But I'm not going to bother my lords with too much of facts. I'm only on 2 paragraphs over here, which deal with the principles by which the constitution is to be interpreted. And straight away on the statement of law, if will have para 66.
This is on what point?
On the interpretation of the constitution. What are the principles which apply to the interpretation of the constitution? Will be with me at para 66. You will find it at internal page 150.
Just give the citation so that.
Yes,
Jamir-
no, I'll do that in 1 second. No, it's 1990. Mr. Jami, 1991 SCC 109. Synthetic and chemicals versus state of UP.
You got it.
And if you will have para 66 of that judgment. With my Lord's permission. Before we deal with the contentions of the petitioner's appellants, it is necessary to reiterate the principles by which these questions have to be judged. It is well to remember that the meaning of the expressions used in the Constitution must be found from the language used. We should interpret the words of the Constitution on the same principles of interpretation as one applies to an ordinary law, but these very principles of interpretation compel one to take into account the nature and scope of the act which requires interpretation. A constitution is the mechanism under which the laws are to be made and not merely an act which declares what the law is to be. It is also well settled that a constitution must not be construed in a narrow or pedantic sense, and that construction which is most beneficial to the widest possible amplitude of its power must be adopted. An exclusionary clause in any of the entries should be strictly and therefore narrowly construed. Note 371A is a negative injunction. No entry should, however, be so read as not to rob it of its entire content. A broad and liberal spirit should therefore inspire those whose duty it is to interpret the Constitution, and the courts are not free to stretch or to pervert the language of an enactment in the interest of any legal or constitutional theory. Constitutional adjudication is not strengthened by such an attempt, but it must seek to declare the law, but it must not try to give meaning on the theory of what the law should be, but it must so look upon a constitution that it is living and organic thing and must adapt itself to the changing situations and pattern in which it has to be interpreted. It has also to be borne in mind that where division of power and jurisdiction is a federal constitution, in a federal constitution is the scheme, it is desirable to read the constitution in a harmonious way. It is also necessary that in deciding whether any particular enactment is within the purview of one legislature or the other, it is the pith and substance of the legislation in question that has to be looked into. It is well settled that the various entries in the three lists of the Indian Constitution are not powers, but fields of legislation. The power to legislate is given by Article 246 and other articles of the Constitution. The three lists of the seventh schedule are legislative fields, heads of fields of legislation. These demarcate the area over which the appropriate legislature can operate. It is well settled that the widest amplitude should be given to the language of the entries in three lists, but some of these entries in different lists or in the same list may override and sometimes may appear to be in direct conflict with each other. Then and only then comes the duty of the court to find the true intent and purpose and to examine the particular legislation in question. Every general word should be held to extend to all ancillary or subsidiary matters which can fairly and reasonably be comprehended in it. In interpreting an entry, it would not be reasonable to import any limitation by comparing or contrasting that entry with any other in the same list. It has to be interpreted as the Constitution must be interpreted as an organic document in the light of experience gathered. In the constitutional scheme of division of powers under the legislative list, there are separate entries pertaining to taxation and other laws. The aforesaid principles are fairly well settled, and various decisions of this court and other courts, some of these decisions have been referred to and so on and so on. Note, what I rely on is not on the interpretation of the entries, but of the articles. Plain meaning must be given to the words used in the articles. It is not possible to add, subtract, or give a constitutional theory to what should have been. What is written on paper, and in my humble submission, as far as 371A is concerned, there is only one meaning possible. There is no ambiguity. There is no plausible second interpretation. There is no choice that is offered for the court to consider which is more appropriate. Nothing of that sort. The article does not contemplate in any manner the grant of any competence. And it can't be read into the article. And in that line, I'll just rely on two quick other judgments, small paragraphs on the notes. One is Kuldeep Nair, to which I'll come back again. This one I'm going to use for 2 points. The first one is on the literal interpretation. And the second is on the principle of federalism. I'll just come to that two notes. But right now I'm relying on literal interpretation notes. Mr. Jamir, the citation is 2006 7 SCC 1. This again, is a constitution bench judgment. Kuldeep Nair versus Union of India. Okay. Mr. Jami, they're also sharing the citation with your junior by WhatsApp. My loads are with me. Lord, as far as this judgment is concerned, if I could request my loads to internal page 87, para 201. 201. 201. Look, internal page is 87, para 201. May I with the note permission? Before proceeding further, we would like to refer to certain objects. I'm so sorry. I'm so sorry.
Yes.
Yes. Before proceeding further, we would like to refer to certain observations of a constitution bench in this court, in G. Narayanaswamy, appearing in para 4, which reads as under. Authorities are certainly not wanting, which indicate that courts should interpret in a broad and general spirit the document which contains the fundamental law of the land or the basic principles of its government. Nevertheless, the rule of plain meaning or literal interpretation described by Maxwell's interpretation of statutes as the primary rule could not be altogether abandoned today in interpreting any document. Indeed, we find Lord Evershed saying the length and detail of modern legislation has undoubtedly reinforced the claim of literal construction as the only safe rule. It may be that the great mass of modern legislation, a large part of which consists of statutory rules, making some departure from the literal rule of interpretation more easily justifiable today than it was in the past. But the object in interpretation and of construction, which may be broader than interpretation, is to discover the intention of the lawmakers in every case. I'm on the intention of the lawmakers. This object can obviously be best achieved by first looking at the language used in the relevant provision. Other methods of extracting the meaning can be resorted to only if the language used is contradictory, ambiguous, or leads really to absurd results. This is an elementary and basic rule of interpretation as well as of construction processes which from the point of view of principles applied, coalesce and converge towards a common purpose of both, which is to get at the real sense and meaning as far as it may be reasonably possible to do this, and what is found laid down. The provisions whose meaning is under construction have therefore to be examined before applying any construction method or construction at all. We endorse and reiterate the view taken in the above quoted paragraph of the judgment. It may be desirable to give a broad and generous construction to the constitutional provisions, but while doing so, the rule of plain meaning or literal interpretation, which remains a primary rule, has also to be kept in mind. In fact, the rule of literal construction is the safe rule unless the language used is contradictory, ambiguous, or leads itself to absurd results. Downloads in my humble submission, 371A does not offer any opportunity of any confusion, any doubt insofar as competence is concerned. It contains no word, proximate or remote, which could even lead to a suggestion that that it is possible to switch competence. Please see para 202 and 203, those two, and I'm done. Regarding the words in Article 84 of the Constitution, with the representatives of each state. As already stated, we are not impressed with the submission that is inherent in the expression representative, that the person, in order to be a representative, must first necessarily be an elector in the state. I'll just pause. This judgment concerns the nomination of the representative to the Rajya Sabha.
From district state.
Yes. So therefore, the argument was that it has to be a resident, he has to be a part of the electorate, only then can he be nominated. The Supreme Court negated that, saying no. Just please see after that. If this concept were to be stretched further, it might also require birth in the particular state, or owning or having rented property, or belonging to the majority caste, etc. of that state. Needless to mention, no such qualification can be added to say that only an elector of that state can represent the state. The representative of state is the person chosen by the electors, who can be any person who, in the opinion of the electors, is fit to represent them. There is absolutely no basis for the contention that a person who is an elector of the state concerned is more representative in character than one who is not. We do not find any contradiction, ambiguity, or absurdity in the provision of law as a result of the impugned amendment. Even while construing the provisions of the Constitution and the RP Acts in the broadest and most generous manner, the rule of plain meaning or literal interpretation compels us not to accept the contention of the petition. I'm saying there is no room for any interpretation, and in line with that, will allow me just two more judgments on this, and I'll
This was a matter of interest because at one point of time, one prime minister belonged to this place.
Yes. And from the Rajya Sabha, which was the
After
first
this
time.
Judgment,
Yes, that was when this judgment came. No, this judgment is.
This footfall into the state became lesser.
No, it is 2006. No, the judgment is 2006. Aptly, it is for that purpose. It is for that purpose. And those would recall that was the first time anybody from the Rajya Sabha had become a prime minister. Otherwise, it was usually an elected member of the Lok Sabha who would be the prime minister.
This was our interest at that time.
Yes. But as we grow, as a nation, when I read the judgments of the 70s and the 80s, when we were a nascent democracy, maybe 25, 30 years in, very different from 70 years in. 70 years in, the broader strokes of interpretation are very different. Far more confident than they were at that time. Now it's a 75-year-old nation. In line with this, if will have one other judgment, which is Sati Devi versus Prasanna. Jamir sir, the citation is 2010 5 SCC 622. I'm so sorry.
Yes.
Yes. Look, in Sati Devi, two paragraphs was just 2010, 5 SCC 622. And if I could request my lords to straight away, please see para 12. If,
Yes.
if lords will have para 12 for a moment. Before proceeding further, my lords are with me?
Yes.
My Lord Justice Chaudhary. Para 12. Before proceeding further, we may notice two well-recognized rules of interpretation of statutes. The first and primary rule of construction is that the intention of the legislature must be found in the words used by the legislature itself. If the words used are capable of one construction only, then it would not be open to the courts to adopt any other hypothetical construction on the ground that such hypothetical construction is more consistent with the alleged object and policy of the Act. The words used in the material provisions of the same statute must be interpreted in their plain grammatical meaning, and it is only when such words are capable of two constructions that the question of giving effect to the policy or object of the Act can legitimately arise. The other important rule of interpretation is that the court cannot rewrite, recast, or reframe the legislation because it has no power to do so. The court cannot add words to a statute or read words which are not there in it. Even if there is a defect or an omission in the statute, the court cannot correct the defect or supply the omission of causes omissions not permissible. It says clearly it's not possible to, an interpretation is possible when there is ambiguity. When there is no ambiguity, there's no question of choosing one of the two principles. In my very humble submission, 371A does not broker any ambiguity at all. It is simpliciter, a defensive article which prevents the application of an act relating to four subjects, and that's it. Stops there. It does not go ahead and confer. What is conferred inherently in the Constitution in terms of list 2 and 3? Yes. You have competence, please go ahead, legislate. But can't encroach on one under the guise of 371A. The other last judgment that I have is Shri Jiaram Educational Trust, and over there just one paragraph. I'm just giving it to you. Jameen Sahab, 2010 2 SCC 513.
Thank you.
The relevant para being para 11 at internal page 516. If nodes will have para 11, nodes page internal page 516. Hello, the with me. May I read?
Yes.
It is now well settled that a provision of a statute should have to be read as it is in a natural manner, plain and straight, without adding, substituting, or omitting any words. While doing so, the words used in the provision should be assigned and ascribed their natural, ordinary, or popular meaning. Only when such meaning, such plain and straight reading, or ascribing the natural and normal meaning to the words on such readings leads to ambiguity, vagueness, uncertainty, or absurdity, which were not obviously intended by the legislature or the lawmaker, a court should open its interpretation toolkit containing the settled rules of construction and interpretation to arrive at the true meaning of the provision. While using the tools of interpretation, the court should remember that it is not the author of the statute who is empowered to amend, substitute, or delete so as to change the structure and contents. A court is an interpreter. As an interpreter, cannot alter or amend the law. It can only interpret the provision to make it meaningful and workable so as to achieve the legislative objective when there is vagueness, ambiguity, or absurdity. The purpose of interpretation is not to make a provision what the judge thinks it should be, but to make it what the legislator intended it to be. Number the 13th constitutional amendment intended to defend the Naga way of life, to preserve the Naga way of life. The 4 exceptions come from the historical documents, the 16-point agreement, the Haider agreement, and all those documents where these 4 points got crystallized and added to the constitution. I ask myself, is it possible to bring within the ambit of these 4 clauses something which is not intended, something which is not stated? If we can't expand the scope of these 4 exceptions, where is the question of adding words to the article? I ask myself, granting competence. In my humble submission, it's not possible at all. Now, while doing this, would also like to consider, please see how competence is granted in the constitution. There are specific words which are used while granting competence. So that will give a nice little contradistinction between what is there in the articles granting competence and how its absence can't be made up by assumptions and presumptions. May please have Article 245, which is the primary article. This is part 11, relations between the union and the states. Chapter 1, legislative relationship. Chapter 2 deals with the administrative part, the executive power, how it is divided. Chapter 1 is legislative relationship, distribution of legislative powers. 245, extent of laws made by parliament and by the legislature of states. Subject to the provisions of this constitution, Parliament may make laws for the whole or any part of territory of India, and the legislature of a state may make laws for the whole or any part of the state. No law made by Parliament should be deemed to be invalid on the ground that it would have extraterritorial operation. Now, please see the words used, subject to the provisions of the Constitution. Parliament may make laws for the whole or any part of the territory of India, and the state legislature of a state may make laws for the whole or any part of the state. Nowhere in 371A do we find these words. We only find a defensive, the hedge saying an act of parliament shall not apply. Please also see 246, I'm not bothering my lords with, that is the distribution of the entries. Please see 246A. Special provision with respect to goods and services tax. Notwithstanding anything contained in Articles 246 and 254, Parliament, and subject to Clause 2, the legislature of every state have powers to make laws with respect to goods and services tax imposed by the union or by such state. 2. Parliament shall has exclusive power to make laws with respect to goods and services tax where the state supply of goods or services or both takes place in the course of interstate trade or commerce. Now, my lords, over here also, my lords will find it categorically says Parliament and subject to clause 2, the legislature of every state have power to make laws with respect to the subject matter concerned, goods and services tax imposed by the union. So, the grant of competence is shall have power to. The field, of course, would recall in this, I think it was the 100th Amendment where they bought in a separate field for goods and services tax in the list, 101st, where they bought in the union list, they got that entry. Now, will also interestingly see 248.
That happened perhaps because the states abrogated their power.
No, over there it was a mix. Because the law itself, the states continue to have the state GST.
State GST.
And then you have the central GST. And then you have, what we call the integrated GST, which is the interstate and also relates to customs, which is would recall, there used to be this countervailing duty, which at the time of import was equivalent to the excise duty on the similar goods. That comes under the IGST, which is the integrated GST. So, that mixture, the amendment took care of everything. And that was subsequently upheld also by the Honorable Supreme Court. Now, please see 248. Residuary powers of legislation. Subject to Article 246A. Now, this was Parliament, but the amendment will see is of it was by the 101st Amendment when the GST was brought in. So 246A took precedence over the residual power also, took the residual power relating to this to GST. Now it says subject to Article 246A, Parliament has exclusive power to make any laws with respect to any matter not enumerated in the concurrent or state list. Such power shall include the power to make any law imposing a tax not mentioned in either of those lists. So, the residuary, the repository of any residual power is the center, not the state. There can be no assumption where the state can denude the center of any residual power. And over here, again, the words are Parliament has exclusive power to make any laws. Power to make any laws. Please see 249. Power of Parliament to legislate with respect to a matter in the state list in the national interest. Now, the rider is national interest, and it's a complete transposition of the state list. Any matter in the state list in the national interest. And it says, notwithstanding anything in the foregoing provisions of the chapter. So, 245 onwards, everything overridden. If the Council of States has declared by resolution supported by not less than 2/3 of the members present and voting in it, voting that it is necessary and expedient in the national interest that Parliament should make laws with respect to goods and service tax provided under 246A or any matter enumerated in the state list specified in the resolution, it shall be lawful for Parliament to make laws for the whole or any part of the territory of India with respect to that matter. It shall be lawful for the Parliament to make any law. 2 and 3 deal with the resolution. I'm not bothering my lord with that. I'm only on the conferment of the competence. Specific words used every time to grant that power. No assumption made, Lords. Now, Lords, please see 250. Power of Parliament to legislate with respect to any matter in the state list if a proclamation of emergency is in operation. Again, a specific circumstance, transposition of the entire list. Notwithstanding anything in this chapter, not foregoing, not after. It is in the chapter. Parliament shall, while a proclamation of emergency is in operation, have power to make laws for the whole or any part of territory of India with respect to notes 246A and anything enumerated in the state list. Note, the second part goes on to say that the law will exist till 6 months after the proclamation is withdrawn. So that's the limitation, Manoj, on it. But the grant of the power is specific and express. DC 252, power of parliament to legislate for two or more states by consent and adoption. Same words. Same words. It shall be lawful for parliament to pass an act to regulate the matters. So note everywhere it is, it shall be lawful for the parliament. Parliament will have the power. Parliament shall make laws. State government shall make laws. The state assembly shall make laws. No, there is no ambiguity anywhere as far as competence is concerned. Now, in 371A, if we are to accept this switch theory or the doctrine of switching of competence, so to say, it would mean reading the words in the provision that absent such resolution, the state government may make laws relating to the four subjects. No, that in my humble submission is not permissible. Clearly. The judicial precedent clearly say that it's not possible to read. The constitution itself lays out how competence is granted. Where is the question of anybody reading anything into the constitution granting competence? That in my very humble submission will not be possible at all. I'm so grateful. My lords had on the previous date indicated. In schedule 6, it had fallen from my lord. In schedule 6, there is a specific provision where if will have schedule 6 of the constitution. The 6th schedule. The articles 244(2) and 275(1), provisions as to administration of tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram. I read this to just make the point Nagaland is not covered. Nagaland is not covered. But it's interesting to read this because if would see, and I'm grateful to my lords for pointing this out, Article 3 over here. Power of the district councils and regional councils to make laws. The regional council for an autonomous region in respect of all areas within such region and the district council of an autonomous district in respect of all areas within the district except those which are under the authority of regional councils, if any, within the district shall have the power to make laws with respect to, and then the fields are given. And lords, if my lords do desire, I could take my lords through each one of these fields. It relates to list 2 or 3.
You can vote for it.
It does not relate to list 1.
One purpose for pointing out this rule, para 3 of 6th schedule is that 3A, the allotment, occupation, or use, or the setting apart of land. These words have been interpreted by the Honorable Supreme Court that does not include alienation of land, ownership and transfer. That is what I pointed out. This 3A,
Manoj,
the allotment,
it does not include
occupation or use or the setting apart of land does not include alienation of land.
land.
And state of Meghalaya has enacted an act whereby it includes alienation of land.
Manoj,
Alienation includes ownership,
Ownership.
transfership.
yes.
Transfer.
ownership transfer.
That is what I pointed out.
Yes, yes.
Then it says that it does not have the power to legislate on alienation of land.
Alienation.
This does not include allotment, occupation, or use of land, does not include alienation.
Alienation of land was because the alienation of
That is
land.
ownership and transfer of
Yes.
land. I don't know about the resources.
Manoj, yeah. But Manoj, over there also, this is the power which was given to the district council
Right.
and regional council. So within the state. And Manoj, over there also, the Honorable Court knows while interpreting a possible conflict, has restricted this entry to mean no ownership. Ownership, as far as land is concerned, would lie with the state government. And Manoj, as it does, no difficulty there. Because in the lists, the distribution as far as land is concerned, ownership is with, in the concurrent list, they will decide. Or the
Because
union.
This is in the context of handing over the land of Nagaland
Manoj.
to the company or somebody to
Yes.
explore. That is for that purpose.
For that purpose, Manoj. And over there,
Indicated.
yes, and Manoj, over there again, my lords will have to consider whether handing over a piece of land, step by step if I go, whether my lords identifying a land can't be falling foul. Handing over the land is for purposes of transfer of ownership of the land and its resources, or for the regulation and development. That my lords will consider in the second part of the argument, lords, because if it relates to regulation and development, then there is no, lords, I don't fall foul of 371A, 1A4. I don't fall foul of it. So, lords, what they will have to demonstrate is that the act, lords, my oil field act, so encroaches their rights that it falls foul of 4. Now, lords, in the resolution, there is nothing to show that these laws fall. There's no application of mind there. No reasons are given. No deliberation. It's just a resolution. So, lords, if there is some back-end debate or there are some...
That 1990 Act has not recognized or has not made mention of any other act other than Mines Act 1952.
Yes. No,
No other central act except Mines Act 1952.
Lord, over there, my lords will be troubled a little, lords, for the reason that...
Go ahead.
Yes.
You're preparing a line of permission, so just
One, two, three, four. Two 278 or something. 278.
1, 2, 3, 4. Equivalent 1, 2, 3, 4. এরকম আচ্ছা next one.
B. Second last page, third last page.
In which paragraph it is appended?
It will be 21.
বুঝেছিস? ঠিক আছে
No, I know, I'm also grateful for my lords for pointing out this out. Lords, if my lords will have after 3, please see 4 and 5 also for a moment in the 6th schedule. Lords. It's very interesting, Lords, and I'm reading it, Lords, because it directly relates to 371A. Please see what covers over here. Lords, land under 3, which Lords, the Supreme Court has held is only without no ownership transfer. Please see 4. 4 says administration of justice in autonomous districts and autonomous regions. So, laws relating to administration of justice are left out, which Manoj is one of the things in the social, customary laws of the Nagas. Please see 5 for a moment. Conferment of powers under the CPC and the CRPC on regional and district council and on certain courts and officers for the trial of certain suits, cases and offences. This also, Manoj, would recall, Manoj, over there it says for the administration of justice, the third clause, Manoj.
There are different courts, hierarchy of courts
Yes,
in Karbi Anglong district or six schedule area
yes,
to administer justice as regards customary law.
yes. And Manoj, I'll also show,
Say marriage between two tribals,
yes,
divorce. It is to be done by the customary court,
Customary,
not by
not by
civil court,
civil court.
family court or
Yes.
something like
Now, Manoj, I'll also demonstrate to my lords over here that, Manoj, the administration of justice, civil or criminal, is in these 3. So, Manoj, it's concurrent. 1 and 3, Manoj, take care of that. So, therefore, Manoj, when the union law doesn't apply, the state automatically has competence because it's in the concurrent list. And therefore, Manoj, to make these kind of concessions is not to, Manoj, cede any or Manoj, surrender any competence or authority. It's an adjustment, which is the contract with the people the Union of India has. Manoj. Now, Manoj, if I could just bring my lords back for one moment to Manoj, that judgment of Kuldeep Nayyar. Manoj. The Rajya Sabha judgment. Manoj, if Manoj will just come back to that for a moment. And Manoj, Manoj, if Manoj would come to internal page 49, para 50. हाँ जी कुलदीप नहीं है दोनों जिन्होंने आपको दिए
Which paragraph? Please come again.
Manoj, please see page internal page Manoj 49.
49.
Yes, and Manoj will see the topic over there, federalism.
Yes.
So this makes superbly interesting reading. Manoj will indulge me, Manoj, 5-7 paragraphs. Because Manoj, I want to establish that federalism is a basic feature of our constitution. And Manoj, any breach of that federalism would be Manoj, or an interpretation Manoj, of 371A, which Manoj, ruptures that federalism, would Manoj, be tinkering with the basic feature of the constitution. So Manoj, this interpretation which is being Manoj, recommended to my lords that there will be a switch on the competence, that Manoj goes and strikes at the root of the basic, and Manoj, notwithstanding will not help here. I'm not dealing with that argument, and notwithstanding is within the 4 frameworks of the constitution. Notwithstanding can't be interpreted to rupture Manoj, a basic feature of the constitution. And federalism is a basic feature of the constitution.
You know, intriguing factor in your argument.
Manoj.
Pages, I don't know whether they will match or not. 270, 307
Of
the brief.
the Manoj, petition.
It goes to affidavit.
No, just
307. It's an affidavit by respondent numbers 1, 2, 3, and 4.
Respondent number. Yes, Manoj, it is. Or affidavit in opposition. Yes.
307.
Yes, Manoj.
Last paragraph. The issue of competence is raised in the first 2 paragraphs.
Manoj, which paragraph number is it, if I may ask once?
First 2 paragraphs, there are 3 paragraphs in that letter, 307, and except B.
Oh, I'm so sorry, Manoj.
Affidavit in opposition on behalf of respondent numbers 1, 2, 3, and 4.
Annexure B, Manoj.
Yes, 307.
Look, I have a really bad copy, Manoj.
Huh.
Yes.
You just see this, you take our copy, you read this. You take this. Mr. Kohli, don't accept.
You may read that. Please refer to your DO letter dated 15 September 15 regarding exclusion of the oil blocks of Nagaland from the purview of the proposed competitive bidding. As you have mentioned, the Government of India has approved the policy of auctioning 89 marginal fields currently held by ONGC and Oil, of which 2 fields are falling in the state of Nagaland. The Government of India and the Government of Nagaland have had series of meetings to resolve the issues regarding the allocation of field blocks for exploration of oil and gas in the state of Nagaland. As stated in my earlier letter dated 14th August 14, it is the endeavor of the GOI to strengthen the federal structure of the country while enhancing the economic status of the states, and the same is achieved only through mutual consent by adopting a course in consonance with the spirit of cooperative federalism. Considering your request, it has been decided to defer the auctioning of the 2 blocks, which are currently held by ONGC for the time being. You are also requested to issue directions to keep on hold the proposed process of allocation of oil blocks by the state government till the issue of oil allocation in the state is resolved.
It's
Note
9
that
years,
it's alive.
9 years.
Yes, no, and 9 years.
That's
No,
why when you were talking of federalism, I came to this, that
no, but this is 2015. Possibly knows when it was
9
100 days
years.
before this court.
9 years.
Yeah, 9 years.
So 9 years government did not assert. The government of India doesn't assert its rights.
So Nagaland is Nagaland is the very sensitive state. We can't deny that. It's a sensitive state. It's a border state. The people are sensitive. We have to take care of that. The stated course and in line with the principles, as I understand, of cooperative federalism, is that there's no bullying.
Photograph here may not be permitted in the courtroom.
No, only of this letter so that we can replace it. We have no copy of it. That's why.
Okay.
Okay. Thanks. I'm so sorry for that.
No, it's okay.
So, to that extent, cooperative federalism would mean that where the government of Nagaland arrives at, essentially, in my very humble opinion, the government of
Okay.
Yes. Manoj, coming to Kuldeep Nayyar, Manoj, and Manoj at para 50 at page 49, if Manoj will have. A lot of energy has been devoted on behalf of the petitioners to build up a case that the Constitution of India is federal. The nature of federalism in the Indian Constitution is no longer res integra. There can be no quarrel with the proposition that the Indian model is broadly based on the federal form of governance. Answering the criticism of the tilt towards the center, T.T. Krishnamachari Sahab, during debates in the Constituent Assembly on the draft constitution, had stated as follows. Sir, I would like to go into a few fundamental objections because, as I said, it would not be right for us to leave these criticisms uncontroverted. Let me take up a matter which is perhaps partly theoretical, but one which has a validity so far as the average man in the country is concerned. Are we framing a unitary constitution? Is this constitution centralizing power in Delhi? Is there any way provided by means of which the position of people in various areas could be safeguarded, their voices heard in regard to matters of their local administration? I think it is a very big charge and to make that this constitution is not a federal constitution and that it is a unitary one. We should not forget that this question that the Indian constitution should be a federal one has been settled by our leader who is no more with us. No, I'm presuming this would be Gandhiji. In the Round Table Conference in London 18 years back. I would ask my honorable friend to apply a very simple test so far as this constitution is concerned to find out whether it is federal or not. The simple definition I have got from the German School of Political Philosophy is that the first criteria is that the state must exercise compulsive power in the enforcement of a given political order. The second is that these powers must be regularly exercised over all the inhabitants of a given territory. And the third is the most important, and that is that the activity of the state must not be completely circumscribed by orders handed down for execution by a superior unit. The important words are must not be completely circumscribed, which envisages that powers of the state are bound to be circumscribed by the exercise of federal authority. Having all these factors in view, I will urge that our constitution is a federal constitution. I will urge that our constitution is one in which we have given power to the units which are both substantial and significant in the legislative sphere and in the executive sphere. So, Mulod, the power given in the executive sphere is part of the federal form of governance. In this context, Dr. B.R. Ambedkar, speaking in the Constituent Assembly, had explained the position in the following words. There is only one question of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that states have been reduced to municipalities. It is clear that this view is not only an exaggeration, but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relation between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principle of federalism is that the legislative and executive authority is partitioned between the center and the state, not by any law to be made by the center, but by the constitution itself. That is what constitution does. The states under our constitution are in no way dependent on the center for their legislative or executive authority. The center and the states are co-equal in this matter. It is difficult to see how such a constitution can be called centralism. It may be that the constitution assigns to the center too large a field for the operation of its legislative and executive authority than is to be found in any other federal constitution. It may be that the residuary powers are given to the center and not to the states. But these features do not form the essence of federalism. The chief mark of federalism, and as I said, lies in the partition of the legislative and executive authority between the center and the units of by the constitution. This is the principle embodied in our constitution. The constitution incorporates the concept of federalism in various provisions. The provisions which establish the essence of federalism, i.e., having states and a center with a division of functions between them, with sanction of the constitution, include amongst others, list 2 and 3 of the 7th schedule that give plenary powers to the state legislature. The authority to parliament to legislate in a field covered by the state under 252 only with the consent of 2 or more states, with provision for adoption of such legislation by other states, by any other state. Competence of parliament to legislate in matters pertaining to the state list only for a limited period under 249 in the national interest and 250 during emergency, vesting the president with the power under 258 to entrust a state government with the consent of the governor functions in matters in relation to matters to which the executive power of the union extends. Notwithstanding anything contained in the constitution, decentralization of power by formation of independent municipalities and panchayats through 73rd and 74th Amendment. Under Article 143 Constitution of India in re special reference number 1 of 1964, this court ruled thus. In dealing with this question, it is necessary to bear in mind one fundamental feature of a federal constitution. In England, Parliament is sovereign, and in the words of Dicey, the 3 distinguishing features of the principle of Parliament sovereignty are that Parliament has the right to make or unmake any law whatever, that no person or body recognized by law is recognized by the law of England as having a right to override or set aside the legislation of Parliament. and that the right or power of parliament extends to every part of the Queen's dominions. On the other hand, the essential characteristic of federalism is that the distribution of limited executive, legislative, and judicial authority amongst bodies which are coordinate with and independent of each other. The supremacy of the constitution is fundamental to the existence of a federal state in order to prevent either the legislature of the federal unit or those of the number of member states from destroying or impairing that delicate balance of power that which satisfies the particular requirements of states which are desirous of union, but not prepared to merge their individuality in a unity. The supremacy of the constitution is protected by the authority of an independent judicial body to act as the interpreter of a scheme of distribution of powers, nor is any change possible in the constitution by ordinary process of federal or state legislation. Thus, the dominant characteristic of the British constitution cannot be claimed by a federal constitution like ours. In state of Karnataka versus Union of India, the Honorable Court observed as follows. Strictly speaking, our constitution is not of a federal character where separate, independent, and sovereign states could be said to have joined to form a nation as in the United States of America, or as may be the position in some other countries of the world. It is because of that reason that sometimes it has been characterized as quasi-federal in nature. In S.R. Bomai, the Constitution Bench comprising 9 judges held as under the significant absence of any expression like federal or federation in the constitutional vocabulary. Parliament's power under Articles 2 and 3 elaborated earlier, the extraordinary powers conferred to meet emergency situations, the residuary powers conferred by Article 248, read with entry 97 of List 1, on the power to amend the constitution, the power to issue directions to states, the concept of a single citizenship, the setup of an integrated judiciary, etc., have led constitutional experts to doubt the appropriateness of the appellation federal to the Indian Constitution. Professor K.C. Vera, in his work Federal Government, what makes one doubt that the Constitution of India is strictly and fully federal, however, are the powers of intervention in the affairs of the state given by the Constitution to the central government and parliament. Thus, in the United States, the sovereign states enjoy their own separate existence, which cannot be impaired, indestructible states having constituted an indestructible union. In India, on the contrary, parliament can by law form a new state, alter the size of an existing state, alter the name of an existing state, and even curtail the power, both executive and legislative, by amending the constitution. That is why the Constitution of India is differently described more appropriately as quasi-federal, because it is a mixture of the federal and unitary elements, leaning more towards the latter. But then what is there is a name. What is there in a name? What is important to bear in mind is the thrust and implications of various provisions of the Constitution bearing on the controversy in this in the regard to scope and ambit of the presidential power under 356 and related provisions. No, just para 58, 59, 60.
You have made the point, no point.
And 63, no, just 4 lines, no. If notes will have para 59. In para 98, Justice Sawant proceeded to observe as under. In this connection, we may refer to what Dr. Ambedkar had said while answering the debate in the Constituent Assembly in the context of Article 355, 6 and 7. He has emphasized that notwithstanding the fact that there are many provisions in the Constitution whereunder the center has been given powers to override the states, our Constitution is a federal Constitution. It means that the states are sovereign in the field which is left to them. They have a plenary authority to make law, any law for the peace, order, and good governance of the state. Thus, the 60. Thus, the federal principles, social pluralism, and pluralist democracy, which form the basic structure of our Constitution, demand that the judicial review of the proclamation issued under 351 is not only an imperative necessity, but is a stringent duty, and the exercise of power under the said provision is confined strictly for the purpose to the circumstances mentioned thereunder. Now, please see 63 now. It was just the first line. True, the federal principle is dominant in our Constitution, and that principle is one of its basic features. But it is also true that federalism under the Indian constitution leans in favor of the strong center, a feature that militates against the concept of strong federalism. Nonetheless, federalism is a basic feature of our constitution. Yes. So, Manoj, given this situation, this, when, so, my case, I'm not pitching at a point where, as has been said in the judgment also, and as the constitution also provides, it is possible. It is possible, for parliament by an amendment to, change the contents of the three lists. That is possible. So, they may say that entry 23, as far as list 2 is concerned, will stand deleted, and now only 53 in list 1 will prevail. That's possible. Or 54 in list 1 will prevail. That's possible. But I ask myself, is it possible for them to do away with list 2? Would that not be infringing the basic feature? Or is it possible for, as my learned friend says, for us to, conjure up a list 4, which is specific to Nagaland, which gives competence to Naga Assembly and relates to those 4 subjects, without a corresponding article saying that as far as this list is concerned, the government or the Legislative Assembly of Nagaland will have the power to make laws. No, that can't be, in my humble submission. This one. I'm so sorry.
Just a query,
Yes, please.
371A. Okay, leaving aside this Roman 4, this is in debate in this suo motu PL.
Yes, please.
But suppose this Bhikkvam, I think Naga customary law and procedure, or religious or social practices of Nagas. There is no act of parliament on religious or social practices of Nagas or Naga customary laws and procedures. Now, there is, suppose this argument for in relation to Roman 4 is accepted, then Nagaland Legislative Assembly will not have any legislative competence to legislate on Naga customary laws and procedure also.
No, that may not be so.
Because
I'll explain that in one moment.
Oh, 1 minute. So, if your argument is to be accepted as regards Roman 4,
Milords.
then Nagaland Legislative Assembly, in the absence of any central act, will not have legislative competence to enact any act on Naga customary laws and procedure also.
No, they will.
How?
I'll explain in a moment. Milords, the religious and social practices of the Nagas. Now, Milords, as I had mentioned earlier also, Milords, as far as Milords would recall, Milords, we had this little bit of a frequent situation in Kerala, Milords, Sabrimala, the temple. Now, that's a pure religious practice. Where Milords, in that temple, for a particular age span of women, they are not allowed. Milords. This is a pure religious practice. But Milords, Kerala doesn't enjoy the freedom that Nagaland does. Now, therefore, Milords, let us say a central act, now, Milords, or the judgment of the Supreme Court saying that no, Article 14 would decimate that provision or that social practice. Would it be possible, Milords, I ask myself? Because the word starts by saying notwithstanding anything in the Constitution, anything in the Constitution is also Article 14. So to that extent, that religious practice is protected. Now, let's come to social practice. I'm just giving illustrations. I'll address this on a more detailed basis the next time. But on social practice, marriages, social practices relating to inheritance, social practices relating to how the interaction between the various members of society or societal or communities takes place. These are all elements of list 2 and 3. These are all elements. I'll demonstrate the entry by entry. These are all elements of list 2 and 3. Naga customary law and procedure. That fell from my loads right now. As far as if it's a Naga versus Naga, it'll go to a separate court. Now, please see the third one, administrative of civil and criminal justice involving decisions according to Naga customary law. Same as the second one, Naga customary law and procedure. Now, may please see administration of civil and may have list 3 for a moment. It will become clear in just 1 second itself. Please see list 3 for a moment. I'll make good this argument the next time when I'm dealing with the 4 subject matters. But I'm just, since the question fell from my loads, I'm just. Please see list 3 concurrent list. Now, the first element is criminal law, including all matters included in the Indian Penal Code at the commencement of this constitution, but excluding offences under laws against laws with respect to any of the matters specified in list 1 and list 2, and excluding the use of naval, military or air forces or any other armed forces of the union in aid of civil power. Criminal procedure, including all matters included in the CRPC at the commencement of this constitution. Please also see 11A, administration of justice, constitution of and organization of courts, except the Supreme Court and the High Court. Now, my submission is not, as I said, the four heads in 371A. For that power is distributed across 3 lists. So, if there is an element which goes to list 2 or 3, absent the central law, the Naga Assembly obviously has the competence to legislate. My problem is that oil fields is in list 1. Please see list 1 for a moment now. And please see the running 3, 52, 53 and 54. Again, I'll dwell deeper on this. But please see 52. Industries, are aware, is entry 24 in list 2. So, which is under the control of the state government. But over here it says industry is the control of which by the union is declared by parliament, by law to be expedient in the public interest, which is where they come out with the IRDA, the Industrial Development and Regulation Act. By declaring expediency under 52, they took a bunch of industries in their control. But Manoj, industries, then I'll take my Manoj through that judgment also, Manoj, Tika Ramji, where Manoj, the Supreme Court held that industries over here means only manufacture. It doesn't mean procuring the raw material. It doesn't mean sale, distribution, and trade and commerce, which are all entries in list 2. Subject only Manoj to entry 33 in list 3. Now, Manoj, please see 53 or 54 before that, Manoj. Regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared by parliament by law to be expedient in the public interest. Now, Manoj, 54 deals with or Manoj is relatable to entry 23 in list 2. Which is mines and minerals. Absolutely identical words. So, Manoj, if for a moment, if the Naga Assembly were to say that the MMDRA Act, the Mines and Mineral Development and Regulation Act, will not apply to Nagaland, they will have to, Manoj, do two things. They will have to demonstrate that it touches, because it's a Development and Regulation Act, they will have to show that this is touching upon ownership and transfer. Land and resources, Manoj, I'm not laboring. Mines and minerals, land and resources. Really, Manoj, can't argue that. But Manoj, they will have to show ownership and transfer. And then say that because it touches upon ownership and transfer and doesn't confine itself to regulation and development, therefore, it will not apply to Nagaland. But Manoj, now please see, and if they do that, then Manoj, under entry 23, they have the legislative competence. No difficulty there. But please see entry 53 on list 1 now. Regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by Parliament by law to be dangerously inflammable. Now, Manoj, this is not subject to list 2. It doesn't transpose anything from list 2. It is not an entry in list 3. This is a standalone independent entry in list 1, which the Supreme Court knows in the Gujarat gas case has said that entry 25, gas and gas works in list 2 is subject to 53. And gas and gas works will relate only to manufactured gas for distribution, not for exploration, not for production, not for processing. That is entry 53. Now, Manoj, in entry 53 is where, Manoj, my difficulty is that where is the Naga Assembly getting competence from? Because it doesn't form part of list 2, it doesn't form part of list 3. And everything else, Manoj, I'll demonstrate to my lords, falls in list 2 or 3. So there is no vacuum. All that I have to show the next time, Manoj, is that the Oil Fields Act is a Development and Regulation Act. It does not touch upon ownership and transfer in pith and substance. And therefore, it doesn't fall foul of 4. That I said, Manoj, in the morning is the mirror argument that the Naga Assembly doesn't have competence. And Manoj, in fact, I was just going to take my notes to those, I believe, Manoj, that watch it. It's 3:30. Manoj will give me 15 minutes. Manoj will give me 15 minutes more, Manoj, so that I can complete this point at least completely. Manoj. Now, if Manoj will have for...
You can deliberate for the next date.
Yes, Manoj. Yes, Manoj. That by itself is a exercise. Yes.
Yes.
Should I continue?
Yes.
Yes. So, Manoj, my submission over here is keeping in view 53. And Manoj, I'll just take my notes straight away to the Gujarat gas case, where the Supreme Court has categorically said oil fields is the sole domain of the union. The state cannot touch it. Now, Manoj, when the Supreme Court has held so, while Manoj interpreting 53 versus list 2 and 3, then Manoj, where is the competence coming from? They are seeking competence in 371A, where they are saying that because once I pass a resolution that it will not apply, then I have competence. I have demonstrated to my lords how competence is granted in the constitution, and there are no words in 371A granting any competence. And it's not possible to read in those words, which the Supreme Court has also said, much as my learned friends may feel it should be read in, that may not be really the jurisdiction of this court, with the greatest of respect. So, they can't go there. Now, may have the Gujarat gas judgment. That's the compilation, and it's page 1. May take it, 53 that I just read has no parallel entry in list 2 or 3. Well, of course, I'm entitled to be surprised if my learned friend does find something, but I couldn't find anything which would touch upon oil fields. And may please see this judgment, which is again a constitution bench judgment. If we'll go to 494 or running page 6 is where the judgment starts. This is the reference made by the President of India under Article 143 AC. Yes. No, this is a reference made by the President of India under Article 143(1) of the Constitution of India. The Gujarat State Legislature passed an act by name the Gujarat Gas Regulation of Transmission, Supply and Distribution Act. The words are very carefully chosen. Transmission, Supply and Distribution Act 2001. Hereafter being referred to as the Gujarat Act, which came into force so and so. The object of the enactment is to provide for regulation of transmission, supply and distribution of gas in the interest of the general public and to promote gas industry in the state. And for that purpose, to establish the Gujarat Gas Regulatory Authority and for matters connected therewith and incidental thereto. The term gas has been defined in the Gujarat Gas as follows. Gas means a matter in gaseous state predominantly consists of methane. This is about just as broad as it gets, because this includes within its conspectus as the court held natural gas when it is extracted and also when it is processed and sold. Methane is what burns. So they said that this definition is too wide. Now, please see after that. The state government legislature passed the said enactment by tracing its legislative competence to under entry 25 of list 2 of the 7th schedule of the Constitution. Parliament has passed various enactments under 53 of list 1 dealing with the matters of petroleum and petroleum products. Entry 53 reads as under regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by Parliament by law to be dangerously inflammable. Entry 25 reads as gas and gas works. So direct conflict. Now, after that we have 246, and may please see para 4 towards the last part of the para where it starts 6 lines up. The Association of Natural Gas Consuming Industries of Gujarat and others filed writ petition before the High Court of Gujarat, wherein they challenge the legislative competence of the union to make laws on gas and gas works. Therefore, the question arose whether natural gas is a union subject or state subject, and whether the state of Gujarat and other states have the legislative competence to make laws on the subject of natural gas. Identical question facing my lords today. It is in this background the following questions were referred to this court under clause 1 of Article 143. Whether natural gas in whatever physical form, including liquefied natural gas, is a union subject covered under entry 53, and union has exclusive legislative competence. Where the state whether states have legislative competence to make laws on the subject of natural gas and liquefied natural gas under entry 25, and whether the act is within their competence. Now, I'll ask my lords to please turn to page. Notes after the entire, if notes will have para 40 at page 506. Yes. Notes, in fact, if notes will have para 35 for a moment, note 504. Which is where notes they deliver the finding on what is natural gas. So it will be a little important. All the material produced before us would only show that natural gas is a petroleum product. It is also important to know that in various legislations covering the field of petroleum and petroleum products, either the word petroleum or petroleum products has been defined in an inclusive way, so as to include natural gas. In Encyclopedia Britannica, it is stated that liquid and gaseous hydrocarbons are so intimately associated in nature that it has become customary to shorten the expression petroleum and natural gas to petroleum whenever referring to both. The word petroleum literally means rock oil. It originated from the Latin terms petra and oleum. Petra means rock and stone, and oleum means oil. Thus, natural gas could very well be comprehended within the expression petroleum and petroleum product. Now, Manoj, may please have para 40. Various legislations passed by the Indian Parliament and the relevant rules would also show that natural gas was treated as mineral oil, resource, or petroleum products. You know, the Oil Field Regulation and Development Act, Mines Act, Mines and Mineral Regulation and Development Act, Petroleum and Natural Gas Rules, Petroleum and Mineral Pipelines, Minerals Pipeline Acquisition of Right of User in Land, etc. Now please see 41. Under entry 53 of list 1, Parliament has got powers to make legislation for regulation and development of oil field, mineral oil resources, petroleum products, other liquids and substances declared by Parliament by law to be dangerous and inflammable. Natural gas product extracted from oil wells is predominantly comprising of methane. Production of natural gas is not independent of the production of other petroleum products, though from some wells natural gas alone would emanate. Other products may emanate from subterranean chambers of earth, but all oil fields are explored for their potential hydrocarbon. Therefore, the regulation of oil fields and mineral oil resources necessarily encompasses the regulation as well as development of natural gas. For free and smooth flow of trade, commerce, and industry throughout the length and breadth of the country, natural gas and other petroleum products play a vital role. In 42, in Kaveri Water Dispute Tribunal, the right to flowing water of rivers were described as a right publici juris, that is, a right of the public. So also the public of the people of the entire country have a stake in natural gas, and its benefits are have to be shared with the whole country. There should be just and reasonable use of natural gas for national development. If one state alone is allowed to extract and use natural gas, then other states will be deprived of its equitable share. This position goes on to fortify the stand adopted by the Union and will be a pointer to the conclusion that natural gas is included in 53 of List 1. Thus, the legislative history and definition of petroleum products, and mineral oil resources contained in various legislations and books, and the national interest involved in the equitable distribution of natural gas amongst the states, all these factors lead to the inescapable conclusion that natural gas is raw and liquefied form, is petroleum product and part of mineral oil resources, which needs to be regulated by the Union. Natural gas being a petroleum product, we are of the view that under 53 list 1, Union government alone has legislative competence. Going by the definition of gas as given in 2G of the Gujarat Act, gas has been defined as a matter of gaseous state, which predominantly consists of methane. It would certainly include natural gas also. We are of the view that entry 25 of list 2 of the 7th schedule, the state would be competent to pass a legislation only in respect of gas and gas works, and having regard to the collocation of words gas and gas works. This entry would mean any work or industry relating to manufactured gas which is used is often used for industrial, medical, and other purposes. Entry 25 of list 2 as suggested by, for the states will have to be read as a whole, gas and gas works. The expression therein cannot be compartmentally interpreted. The word gas in the entry will take its color from the other word gasworks. In Ballantyne's Law Dictionary, gaswork is defined as a plant for the manufacture of artificial gas. Webster's is defined as an establishment in which gas for heating and lighting is manufactured. Free Dictionary, gaswork is explained as a manufactory of gas with all the machinery and appurtenance, a place where gas is generated. The meaning of the term gasworks is well understood in the sense of the place where the gas is manufactured. So it is difficult to accept the proposition that gas in entry 25 of list 2 includes natural gas, which is fundamentally different from manufactured gas in gasworks. Therefore, entry 25 would only cover manufactured gas and does not cover natural gas within its ambit. This will negative the argument of the states that only they have exclusive powers to make laws dealing with natural gas and LNG. Entry 25 of the list 2 only covers manufactured gas. This is the clear intention of the framers of the Constitution. This reading is in no way make the entry a useless lumber as feared by the states, because natural gas was never intended to be covered by that entry. It is also difficult to accept the argument of the state that all gas would be categorized as dangerously inflammable, and thus arriving at the conclusion that natural gas is also covered in the state list, because this difference is not based on the character but on the manner of its origin. In view of the specific entry of 53, for any petroleum and petroleum products, state legislature has no legislative competence to pass any legislation in respect of natural gas. To that extent, the provisions contained in the Gujarat Act are lacking legislative competence. Now, Manoj, this is relating to natural gas vis-a-vis entry 25. Manoj, luckily for me, petroleum and petroleum products, mineral oil, has no mention in list 2 or 3. So, Manoj, gas and gas works, there was the probable existence of a Manoj, difference of opinion, which is now settled by the court. But as far as petroleum products is concerned, no confusion also. Nobody can claim any competence except Manoj, the union. Now, given this situation, Manoj, in my very humble submission, 371A does not grant or confer any competence on the state legislature. The state legislature on its own does not have any competence relating to petroleum and petroleum products. And therefore, Manoj, the Act, the regulations, and the rules must.
According to your submission, it can delay.
I'm sorry, Manoj?
Without taking a resolution, it can delay.
Yes, Manoj, it can delay the application of the Act.
Yes, application.
Provided, Manoj, they're able to show that the Act impinges on transfer and ownership. Which also, Manoj, my lords will decide if the Act, Manoj, if the Oil Fields Act or the Manoj PNG rules by the union do not impinge on ownership, and Manoj, then the court will declare that they apply. Manoj would like me to just answer that question which fell from my lord, Manoj, relating to the estoppel part, because there was a question in the parliament, Manoj, or should I do that next time? I'll do it next time, Manoj. Grateful, Manoj. Manoj, I'll take, if Manoj do give me 2 sessions, Manoj, I'll take 1 day to complete the other argument, Manoj, relating to that the Act applies and it doesn't impinge.
You have to concise, because
Manoj, I tried doing my best. Manoj, I finished this whole part today as fast as I could. Manoj, I'll take, Manoj, I'll try to concise it as.
because you have also heard the Advocate General. He's saying that you have digressed from from where the Mr. Jain had left.
Manoj, but if
No, it's okay. I'm not commenting.
no, Manoj, with due respect to Manoj, the submission, Manoj, I do believe I've addressed the issue on hand, Manoj.
No, definitely. Otherwise, we would have curtailed your.
Yes, yes. I wouldn't have got the indulgence I did, Manoj, if it.
6th. Mr. Jamil, your Advocate General is suggesting 6th of September.
No problem.
Would I consider 9th or 10th? 9th or 10th? I can do both. Lords, 9th or 10th? Would my lords consider both the days, Lord, so that we can finish it? I mean, I don't know. No, 9th. Convenient.
It's a Friday.
I'm sorry?
Yeah, Mrs. Jamil, we are losing your voice. Please come again.
It's a Friday. Will it be not too risky if it is not finished on that day?
No, because
8th is
Am
a
I
Sunday.
audible?
9th,
uh,
9th of September
That should be okay.
9th is Monday.
is a Monday, my lords.
Then it's all right.
Okay. 9th.
Monday.
The names of the council in the last order sheet. Last order. There you can copy.
Lord, my only prayer is, Lord, I believe last time my name in the order sheet was missing. In the appearance.
No, it's there.
I'm looking in the body of the order, Lord, but I believe in the appearance it got missed. Lord, if Lord, then,
No, I think you got a wrong order.
oh,
Will be
okay.
definitely there.
No, and that's good enough for
No.
me, Lord. It's good enough for me. No need, Ji.
No, it's okay. That's
No. I'm grateful, Lord, Vivek Kohli.
make it Vivek Kohli. Same order. They say that the list as agreed to by all sides, list on 9/9/2024 as a part of the.
Lord would consider, Lord, that prayer I made in the morning about, Lord's the 6 reliefs that have been sought and the probable 7th. Lord.
No, I don't think we'll reserve that. There are reasons. We'll
Steno, sir.
We'll tell you.
Last appearance. What date?
Not here, but we can invite
Challenge
you.
that order.
You can invite, we can invite you and the Advocate General to the chambers. We'll tell you why.
No, I'd be grateful. That my lords would think it worthy.
When you come out, you can come in the chamber and we'll tell you why.
Grateful.
I understand.
Because of your neighborhood, you will understand. You get the hint? Sure. On the next date, we'll tell you the records which we are having is not in an appropriate order. So therefore, page numberings times are not matching. We will be reconstituting this brief with the writ petition first and the affidavits in order of their filing, date of filing. Because otherwise, we are finding it very difficult to find out documents because it's not in a serial order. So,
We'll also take that for.
so that's why we'll give it to you, the list which we are preparing. The index will prepare and give it to you on the next date. So that.
Grateful.
On to item 6. Pronouncement of judgment, item 12 and 13.
Lords, I pray for listing a pending review petition for withdrawal.
Single bench, item 7 for orders. Review petition 144/24.
Friday, my lord. On Friday, my lord, last same matter has been notice has been issued, my lord. My lord, I filed and my lord reopened, my lord. My lord.
You moved the matter on Friday. Notice was issued.
Yes.
This review. This is case number, review petition number.
145.
139, my lord. 139.
139. So number one, review petition number 139. You have
My lord, here is the, my lord, one left of my lord.
it will be.
One to minute, I was directed to extra for this search, my lord. Notice,
Okay, same order.
where is the sentence notice issued from, not here. my lord.
Oh, acha. You have to say issue notice. Para 2, issue notice. Returnable in a week. This para 2 and 3 will change. 3 and 4. Okay.
And for social justice.
For social justice.
I'm appealing for the health department.
Social justice, instead of Miss Terongpi. Earlier, Miss Terongpi had appeared.
No, Terangpi, my lord, for the department, my lord, education department, social
Okay.
in all the matter, there is social.
Number 3 is social empowerment. Miss D. Jain was there.
Yes, sir.
Acha.
This is my quality.
Mr. H. Sharma,
She Sharma.
C. Sharma, instead of Miss D. Jain. And your name?
IDAS on behalf of the Upamanna.
Your name?
IDAS.
Idas. On behalf of Mr. D. Upamanyu. Here it is B, huh? The spelling mistake, it is D. D. Okay. In a week. Extra copies within 2 days.
Item 8,
Same, my lord.
Same.
Same, my lord.
Okay, same. 8 and 9 also same.
Yes, my lord. Only my lord. Nika das my lord. Same,
8 and 9 same.
same, my lord.
Same one. Okay. Yes.
10 with 11.
But as per your Lordship, my lord, order, paper publication was made, my lord. I have filed an affidavit, my lord, on 12th August. But
There's no
that
affidavit here.
affidavit is not in record.
Okay. Mr. K. Kalita, the counsel for the applicants, has submitted that pursuant to order dated 26/6/2024, a notice was issued in the newspaper. And an affidavit to that effect was filed on
12/8,
12/8/2024.
yes.
2024. That's what they said. Let this said affidavit be tracked and tagged with the record and be listed thereafter. List accordingly.
Yes, ma'am. Date, my lord,
It'll come whenever it is tagged. You will just pursue the matter in the registry
yes, ma'am, obliged.
because the single bench are not sitting regularly, so therefore the office will give a date. Okay.
Yes, ma'am.